Welcoming everybody to the committee. Welcome to the first hearing for the inquiry into animal welfare policy in New South Wales. The inquiry was referred to this committee by the Minister for Agriculture and Western New South Wales and relates to the New South Wales Government's draft Animal Welfare Bill 2022. The inquiry is examining the state's animal welfare policy, regulatory and legislative framework, including any measures to streamline animal welfare laws, reduce and remove unnecessary regulation, and ensure existing policy and regulatory arrangements remain appropriately balanced. Before I commence, I would like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land on which the Parliament sits. I also acknowledge the traditional owners of the lands in which all meeting participants join us today. I pay my respects to the elders, past, present and emerging, and extend that respect to all Aboriginal people watching. Before we commence, I would like to make some brief comments about the procedures for today's hearing. Today's hearing is being held virtually and in person and is being broadcast live via the Parliament's website. A transcript of today's hearing will be placed on the committee's website when it becomes available. In accordance with the broadcasting guidelines, media representatives are reminded that they must take responsibility for what they publish about the committee's proceedings. While parliamentary privilege applies to witnesses giving evidence today, it does not apply to what witnesses say outside of their evidence at the hearing. I therefore urge witnesses to be careful about the comments you make to the media or to others after you complete your evidence. Committee hearings are not intended to provide a forum for people to make adverse reflections about others under the protection of parliamentary privilege. In that regard, it is important that witnesses focus on the issues raised by the inquiry terms of reference and avoid naming individuals unnecessarily. All witnesses have a right to procedural fairness according to the Procedural Fairness Resolution adopted by the House in 2018. There may be some questions that a witness can only answer if only they had more time or with certain documents to hand. In these circumstances, witnesses are advised that they can take a question on notice and provide that answer within 21 days of receipt of the transcript. I now welcome our first witnesses, and I would ask each of you to state your name and position and title, perhaps beginning with Ms. Flood. Could you please state your name, position, title, and swear either an oath or affirmation? Thank you.
Thank you. My name is Rochelle Flood and I'm the Campaign Manager at World Animal Protection Australia. And I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Benyon, could you please state your name and position, title and swear either an oath or an affirmation?
Nicola Bynan, Head of Campaigns at Humane Society International. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Dr. Goodfellow?
Yes, Jed Goodfellow. I'm here as a consultant with Humane Society International, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. And Ms. Vesk?
Christina Vesk, CEO of the Cat Protection Society of New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. Would anyone like to make an opening statement? And I might let you know that we will take opening statements, then Ms. Hurst is going to lead off the questioning, and the members of the committee are going to try and, if they have a question in relation to that topic, we've just decided we're going to try and work cooperatively to conduct the questioning that way and allow a very short amount of time at the end in case you feel anything important has been missed. So, Ms. Flood.
Thank you for the opportunity to present evidence to this inquiry. I'd also like to start by acknowledging that we're meeting on the traditional land of the Gadigal people of the Eora Nation and that I also pay my respects to elders past, present and emerging. Animal welfare law in New South Wales has failed to keep pace with scientific and expert advice, as well as community expectations regarding how animals should be treated. Our regulatory system continues to permit outdated practices that are not in line with global best practice. The public is losing faith in the ability of the state and the industry to maintain appropriate standards of animal welfare. World Animal Protection recognises that this draft bill does offer a number of improvements, which we welcome. However, we do have further recommendations that we believe would strengthen this legislation. First, World Animal Protection encourages the committee to include a clear recognition of animal sentience under Section 3 in the objects of the bill. Sorry, pardon me. Other Australian and international jurisdictions have now moved to include animal sentience within similar legislation. There would be reputational and trade benefits to New South Wales by including the recognition of animal sentience under this legislation. Previously, the failure of Australian jurisdictions to include a reference to animal sentience has resulted in a low ranking within World Animal Protection's Animal Protection Index. This reform is a unique opportunity to move in line with other jurisdictions and to ensure that our animal welfare laws are in line with best practice. Second, World Animal Protection recommends encouraging the committee to consider the creation of a dedicated portfolio for animal welfare, as well as an independent office for animal welfare. There is an inherent conflict of interest within the current system whereby the oversight of farmed animal welfare sits with the Department of Primary Industries and the Agriculture Minister. The DPI and the Agriculture Minister are also responsible for ensuring the profitability of the agriculture industry. Sometimes what is best for animal welfare may not be the most profitable option, and we need to ensure there's a level of independence there to maintain public confidence in our animal welfare system. Third, World Animal Protection would like to see greater clarity around how standards are to be adopted and how they will relate to the minimum care requirements outlined in the draft bill. On a related point, we recommend expanding the list of prohibited and restricted procedures to include additional practices that lead to poor welfare outcomes. Finally, we support the harsher penalties that are proposed under the current bill. However, we would like the committee to consider creation of a specialised court for animal welfare, similar to what we have with the Land and Environment Court, because this is a very complicated area, and even with harsher penalties available, failure to recognise the implications of poor animal welfare can still result in low sentencing. There were a number of other recommendations that we did put forward, and we're of course happy to take questions. Thank you very much.
Thank you so much. Much appreciated. Ms. Besk?
Oh, thank you. Thank you for the invitation to be here today. Cat Protection's submission to the inquiry focused on the draft bill, and as we said, in the absence of seeing draft regulations and any standards made under them, it's not possible to properly assess the animal welfare reforms, as the bill mainly sets a high-level framework of minimum basic requirements. I reiterate our comments made earlier in the consultation process. In our June 2020 submission to DPI's issue paper, Cat Protection noted the reforms needed to embrace the following principles: animal sentience, the 5 domains model, a one welfare framework, ethics and enforcement. In response to the July 2021 DPI discussion paper, among other things, we recommended that any new law would need to prioritise animal health, welfare and well-being. The objects should recognise animal sentience and include a focus on positive animal welfare. The law should adopt a one welfare framework that acknowledges the intersections of human, animal and environmental health, safety, welfare and well-being. Alternatively, references to One Health or the World Organisation for Animal Health Global Animal Welfare Strategy. The animal welfare reform process has been welcome, but the pandemic has stretched the resources of the veterinary and animal care sector enormously, and I don't feel we've had adequate time for consultation. I've seen many excellent points made in submissions, including those of World Animal Protection and Humane Society International. I plead the case for another consultation draft with the attendant draft regulations, standards and guidelines. The pandemic itself illustrates why we must pursue a One Health, One Welfare framework for animal welfare law. The interrelationship between human, environmental and animal health and well-being is beyond all doubt. Animals deserve our protection, they deserve care and compassion and the chance to live their best life. This is an opportunity for New South Wales to lead the way in better animal welfare for the sake of everyone. Whether they particularly like animals or not, good animal welfare is good for us all. In the words of Pope Francis in his 2015 encyclical letter on care for our common home, our indifference or cruelty towards fellow creatures of this world sooner or later affects the treatment we mete out to other human beings. We have only one heart, and with the same wretchedness which leads us to mistreat an animal will not be long in showing itself in our relationships with other people. Every act of cruelty towards any creature is contrary to human dignity. I thank the committee for your time.
Thank you. The Humane Society.
Thank you, Chair, committee members. I'd also like to acknowledge that we're meeting on the lands of the Gadigal people and pay my respects to their elders past and present. Thank you for the invitation to give evidence today. I'm Head of Campaigns for Humane Society International, and Dr. Jed Goodfellow is our consultant, and he's an expert in animal welfare law reform and was the author of our submission. To summarise our view of the bill, we agree that it does contain several positive improvements on the current POCTA law, but overall we think that the bill falls short of today's benchmarks for a modern animal welfare regime. If passed in its current form, it would be a missed opportunity. To speak to the positive side of the bill first, we're pleased that the bill will consolidate 3 separate pieces of legislation, making it easier to navigate and administer. It simplifies and improves offence provisions, clarifying requirements for animal owners, and it expands the definition of animal to cephalopods and decapods, which is important. It creates an obligation to provide animals with appropriate opportunities to express their normal behaviours, and it includes psychological suffering within the definition of harm to animals, and establishes an Animal Welfare Advisory Council. These are all very welcome positive improvements. However, the bill misses a number of other important opportunities to bring New South Wales into line with standards of contemporary animal welfare law. It's disappointing that the bill maintains the basic deficiencies of the traditional animal welfare legislative approach in carving out entire categories of animals from its protections without conditions, not on any scientific basis, but according to the use that the animals are put to. In other words, treatment or a mutilation that would be considered outrageously cruel and an offence if you did it to your pet dog is exempt when done to a farm animal because it's in line with a standard or guideline which provides an exemption. So we recommend that the bill is amended to ensure that there is a more consistent, principled and scientific basis upon which the standards for animal welfare are developed and applied. The bill also fails to recognise animals as sentient in its objects. To recognise sentience would be a true marker of a modern animal welfare regime, evolved beyond treating animals as mere commodities and possessions. We'd also like to see structural reform and the establishment of an independent animal welfare authority to administer the legislation. Very urgently needed is an improved regime for the development and adoption of animal welfare standards with clear procedures and outcomes-based criteria. We're also concerned about the significant range of issues that are deferred to the regulations and prescribed standards when they're absolutely essential to how the Act functions and delivers animal welfare. If I can make some concluding arguments, wholesale legislative review of this kind does not occur very often, and it would be highly regrettable if this opportunity is missed and we have to wait another generation for the reform that the community expects. As the most populous state in the country with significant animal-based industries, we'd like to see the New South Wales Government leading the way and setting the bar high. As a state also very populous by animal numbers, this bill will impact the lives of hundreds of millions of animals over the next decade. In care, at any one time in New South Wales, we've 31 million meat chickens, 20 million sheep, nearly 5 million layer hens, 3.6 million beef cattle. I could go on, but we all get the sense of the responsibility that is upon us with this legislation. So we look forward to the bill being amended to meet the standards of animal welfare that the community expects for these animals, and we hope our comments and evidence today will be helpful in this objective.
Thank you very much. Thank you for those statements. The Honourable Emma Hurst.
Wonderful. Thank you so much, Chair, and thank you all for appearing today. I'd like to turn to Dr. Goodfellow. I believe that you were the author of the submission. One of your recommendations is that the bill should include recommendations for the making and adoption of standards under the Act, including consistency with the objects and duties of the Act. Can you explain why this is important and how it would work in practice?
Yeah, well, thanks, Ms Hurst. Yes, this is really important because in Australia at the moment, as many committee members may know, there's no prescribed or definitive framework for setting national standards. And of course, national standards relating to farmed animals or animals in other contexts are very important in terms of the numerical significance of those standards. So, and plus, when you combine that with the exemptions that are in the current bill, it effectively means that the vast majority of animals, in terms of what their welfare standards are, will be governed by those industry-based standards rather than the principles and the duties within the primary Act itself. So we think it's extremely important that the process for setting those standards is actually prescribed in the legislation, similar to what the New Zealand Animal Welfare Act does, because that increases the level of accountability and integrity of that process, and so that we can ensure that those standards are based on animal welfare science, the community's views are reflected in the process for developing them, and that we have a more robust, accountable process.
And you mentioned this a little bit in your answer, but you are quite critical of the exemptions in the bill. How do they compare with other states around Australia, and what are your big concerns with the exemptions?
Yeah, look, most states and territories do include exemptions and or defences for compliance with standards and codes, and other even broader exemptions and defences where there is no existing standard that sets the parameters for that exemption. In terms of the way the exemptions are drafted, we would certainly like to see more conditions placed upon those exemptions, so that we at least have a more consistent framework that doesn't just carve out entire categories of animals. So we've provided a couple of recommendations in relation to that. I think as a basic principle, we really shouldn't be providing exemptions where there is not some kind of definitive prescriptive standard that provides certainty around the scope of those exemptions. Because we don't want to get into the territory where we're inadvertently permitting, acts of quite egregious cruelty because it fits into one of the exemptions. So we need to be very clear about what the parameters for those exemptions are, and that's where the bill can certainly be strengthened.
Would you mind just giving an example of that?
Yes, so if we look at some of the exemptions that are currently in the bill, we can see that there is reference, of course, to the qualification of causing animals no unnecessary harm, whether it be in relation to performing a routine husbandry practice or other practices such as religious slaughter. Not for religious slaughter. Religious slaughter has no qualifications whatsoever, which is quite a significant oversight. At the very least, there should be the no unnecessary harm qualification placed on the exemption for religious slaughter. But that unnecessary harm qualification is, as we know, very, very much open to interpretation. So it doesn't provide a lot of guidance as to the scope of those exemptions. So, yes, as a basic principle, wherever we're looking at exemptions from the minimum standards of care under the Act, there really should be a standard, a code that is recognised within the legislation to provide definitive detail around what acts are actually exempt and what will benefit from those exemptions. And then in addition to that, we really want to see the process for developing and adopting those standards actually prescribed in the legislation, because at the moment it's just an ad hoc process. And we see with the example with the poultry standards, We've just entered the 7th year of that review process, and there's still no end in sight for that review process. It's been a very, very difficult, long, lengthy process. Doesn't provide certainty for industry, doesn't provide certainty for animal welfare stakeholders or the general community. So prescribing a process within the legislation will really assist those processes in the future.
Prescribing it in the regulations be acceptable?
Look, it would be certainly better than not having them in the regulations, but because of how important and how central it is to the operation of the legislation, we think that those conditions should be placed in the Primary Act itself. And again, we refer to New Zealand's Animal Welfare Act as a great example for how that should occur.
Thank you, sir.
So it's hello, by the way. So it's the process of setting those standards as well as what ends up in those standards.
Yes.
At the moment, there is this sort of there's a bunch of different codes and standards under the legislation that is in various states of update, and consultation processes don't seem to be well defined.
Very clunky.
So you're directing us towards the New Zealand legislation as being sort of the model that we could adopt if we were to sort of do that a bit better.
Yes, that's right, and you're correct. It's not we're not just talking about the process. The process is extremely important in terms of what considerations should be taken into account in developing standards, but also it would be great to see objective thresholds and criteria for the outcome of those standards as well. So consistency with the principles and the duties outlined in the Primary Animal Welfare Act, the Act that adopts the standards, would be a key feature of those conditions.
So can I take us a step back then in terms of those principles of the legislation and what we base it on? And I know that in the consultation paper and in the responses, it was very clear that there was a huge, what I saw anyway, as a large number of submissions being in favour of animal sentience being recognised within New South Wales legislation as being the baseline. In your view, and I'll ask all of you this, what does it mean if we fail to recognise animal sentience as being a fundamental principle of this legislation? Do you want to start, Ms. Flood?
Sure. So from our perspective, failure to recognise animal sentience up front, it has implications for the operation of a large part of the legislation. So, for example, with the sentencing and the proposed harsher penalties under sentencing, recognising sentience provides a bit more guidance to courts around why it's significant, why animal welfare infringements and crimes have an impact because they're sentient creatures. And similarly with the practice in farm animal welfare in particular, recognising sentience would help to ensure that procedures weren't permitted that would cause undue harm to sentient creatures. So it would strengthen the guidance around what procedures should be permitted, and hopefully would give more guidance on which ones shouldn't be given exemptions. And we are still seeing quite sweeping exemptions here at the moment.
And could you perhaps, either Ms. Flood or any of you, explain, I think sometimes when we're talking about embedding animal sentience within legislation, people get very concerned that means that then everything will be off the table in terms of the use of animals in society. And so, people say that hunting will not be permitted or whatever. And we could go down that track as to what we think should and shouldn't be permitted. But could you explain how that's not the case, that when you embed sentience, there is still then sort of permitted activities, but how embedding sentience is still important before we do that exemption process?
I can offer one response to that, and I think we can look to other examples of jurisdictions that have included sentience within their legislation. So the ACT has now enshrined reference to animal sentience, so too has New Zealand, and the European Union's laws also recognise sentience, and we can see from those examples that it hasn't sort of opened the floodgates, so to speak, in terms of prohibiting every use of animals, that all of those jurisdictions still have farming and they still have all of those practices that you would expect. However, it has led to improved welfare standards and that fundamental recognition of the importance of animals and the need to treat them humanely.
Can I just on that? So, but it's not just not the jurisdictions themselves, is it? So, like the free trade agreement with the recent UK free trade agreement has a whole chapter set aside around animal sentience. Would that not be right?
Yes, it did. So that free trade agreement has a dedicated animal welfare chapter. It's the first of its kind, and it has now enshrined animal sentience. And so if New South Wales, as one of the key primary producing states, were to also enshrine animal sentience within our legislation, it would be beneficial for future trade negotiations and our perception globally.
And do you think future free trade agreements, such as if the EU are heading down this path, do you think a future FTA with the EU would also include a chapter around animal sentience?
Yes, I think that would be quite likely, given we've seen that example now from the UK, yes.
And just to add to that, the operative implications of recognising sentience really depend upon the way the legislation actually recognises sentience. So if it's a simple recognition of animal sentience in the objects of the bill, that's not going to lead to any direct operational impact upon the minimum standards of care or the cruelty provisions. It's simply a recognition of as Rochelle said, the reason for why animal welfare matters. It's a strong symbolic statement, and it could provide further guidance to interpreters and enforcers of the legislation as well, in terms of how they, particularly in cases of ambiguity, how they determine what the appropriate application of the law should be. And you're very right around animal sentience now being part of Australia's trade policy, and absolutely the EU will be demanding from Australia similar, if not higher, provisions for access to their markets.
Similar to sentience, and something we've received a lot in the submissions, particularly from industry submissions, is to remove the idea of psychological suffering in the bill, because the claims are that it's non-scientific and impossible to measure. I wanted to get your opinions of that, and whether psychological suffering should stay in the bill and why.
I mean, there is voluminous scientific evidence to show that animals are capable of experiencing psychological suffering. I did review some of those submissions, and I've got to say they're quite disappointing, because, many of the industry groups that are proposing to remove psychological suffering from the definition of harm are benefiting from the exemptions in any event, so they're protected in that sense. But to suggest that there is not strong science on the fact that animals can suffer harm, and to suggest that we shouldn't be making the causation of unnecessary psychological suffering to animals an offence is something I don't think the Australian community, the New South Wales community would agree with.
Dr. Goodfellow, could I ask you to submit after this hearing, just for the benefit of the committee, some of those research papers that show that animals do have psychological suffering? I think that would be quite useful for us to see those. I want to ask, if couldn't move on to something else, I want to talk...
Sorry, can I
Yes, sorry.
Yeah.
just, in that research, does any of that research make a distinction between, I guess, psychological suffering and a natural reaction of an animal, in terms of like a wild animal where they maybe have a heightened sense of awareness and, they might be running away, or they're scared. It's a natural reaction. It's a flight mechanism rather than a psychological suffering. And I guess my other point is, how, in other jurisdictions, is that psychological suffering measured and assessed, and who is best placed to do that? Because a lot of the concerns around the psychological suffering from the submissions has been the subjectivity of that and how it would be assessed. Because I question whether RSPCA has the technical knowledge to actually do that, whether anyone does.
Yes, well, there are certainly experts that can provide very objective scientific measures of an animal's, what's referred to as an animal's affective state, the psychological state of the animal, the mental state. And this is, very, very much well settled in the science. So in terms of, if the issue is around the measures used to assess an animal's psychological state, then yeah, there's certainly a lot of guidance on that. Now, whether or not that would be incorporated in the legislation, I think that would be difficult to actually insert the measures of psychological suffering in the law. It's more of a matter that the courts would decide based upon the expert evidence that is provided to the court. In terms of enforcement, that would also depend upon the enforcement guidance around particular industries, if that's the area of concern. So whether it be in a certain intensive livestock facility, there would be guidance to enforcement officers around, what is acceptable, what is not acceptable. But again, come back to the fact that there are prescriptive standards and exemptions anyway that are providing that sort of certainty for the industry. So I think it's unfortunate that industries that are already benefiting from those exemptions would then seek to withdraw those protections for all of the other species of animal that have the capacity to experience psychological suffering, where that's not going to impact their industry at all. So, and we can certainly provide references to the scientific literature.
May I add something to that?
Yes, of course.
I think this is one of the reasons that I know that we spoke in our submissions, and others have as well, about the 5 domains model. And I happen to bring some copies of an article which might be helpful in explaining. And it does go to your point about how do you do these assessments. It's not about, I agree, you can't just put that in legislation, it's this, it's that. It's an evolving science, but the science is definitely in that, confirms animal sentience, that confirms the suffering, confirms psychological suffering. What that model does, and I'm not qualified to fully explain it, it's really detailed science, but it looks at environments, things like food, and how these affect an animal's mental state. So you can actually, when you're drilling down to the levels of standards and guidelines for certain functions or facilities, there can be specifications in there that are scientifically shown to benefit or disbenefit an animal. So things like access to food and water are very obvious, but in the case of cats, being able to hide somewhere, so on. But that is quite a recent article, and I think you might find it really helpful.
Thank you. Miss
Sorry, can I just...
Can I just touch on a couple of things we've been over before?
Maiden speech.
In relation to I did have a crack yesterday.
You had a point of order which didn't go too flash yesterday. That's okay.
I got one up. Sorry, in relation to the standards, Dr. Goodfellow, if I can just check, what you're proposing is that in the bill there is sort of a process of how those standards are developed and approved?
Yes.
Would that then take away the need to have things listed in the prohibited actions because it strengthens up that around that standards?
Look, we would certainly still support having the list of prohibited procedures and other prohibited activities within the bill itself, because that just provides certainty for everyone around where those prohibitions lie. So, I mean, we would be seeking both that there is a process and criteria for setting and developing those standards, plus the list of prohibited procedures as well, incorporated into the primary act itself.
The standards and guidelines are often not comprehensive, and given that they're often federally developed, you can have quite a significant time lag with updates to them. So there's definitely advantages to having the prescribed list in addition to the standards.
Would including that process in the bill, though, not increase the, integrity of those standards?
It would improve the process for the standards, which is for the standard setting and development, yes, which is definitely needed.
And sorry, just back on the issue of sentience, was sort of been implied that bringing it in is not going to cause a threat or a change of practices happening in some of these industries. Is it then symbolic rather than having any broader outcomes?
No, I would not say that it's simply symbolic. It does help with interpreting the other provisions of the legislation, and it provides guidance to courts as well as to people who have animals within their care. So it does have an impact, and there are certain procedures that we were quite upfront about in our submission, such as mulesing done without pain relief, that we do not believe are appropriate to be performed on sentient creatures. So there will be some implications quite clearly from recognising sentience, and that's why we suggested including those additional restrictions under the prohibited procedures section. So it isn't just symbolic, it provides interpretation.
Can we just, to round that discussion out then, so when we're looking at sentience as, it's really about, okay, so I'm going to put this to you and then you tell me if I'm completely wrong, but my understanding is that by recognising sentience, you are recognising not just an obligation not to be actively cruel to animals, but also to a responsibility to provide for animals to have, a decent enough life, I guess. So that, I think that distinction is often what we talk about when we talk about the community's attitudes to animal welfare versus our current policy in animal welfare. Our current policy is very much about not doing outwardly cruel things, whereas I think community expectation has moved towards doing a more proactive, taking responsibility for animals in your care. If we embedded sentience into the legislation, do you think it would then have a permeating effect on the rest of government policy in sort of setting out, well, actually, government has a positive responsibility to look after animals in this state?
Yes, I think that's a great summary of some of the benefits of recognising animal sentience. Fundamentally, it's about recognising why animal welfare matters, why we're all here, why the first ever animal protection laws were passed in the world. It was because of a recognition that animals are sentient, they have the capacity to suffer, therefore their interests matter in a moral and ethical sense. So it's really just putting that up front, right in the objects of the bill, to ensure that anyone who's interpreting the legislation has that understanding that that is why animal welfare matters. It also matters for other instrumental reasons, but such as improving community confidence and improving general civilisation, the way we interact with one another. It can have a deleterious effect on society as a whole if we're not, treating animals humanely. So they're all very positive, important reasons for treating animals well, but it's also fundamentally important that we're treating them well because it matters to the animals themselves, because they're sentient, and that's the reason why recognising sentience is important.
I'm going to move now to the Honourable Nick Veitch and then back to Emma Hurst.
Thanks.
Just a fascinating conversation around sentience, but I think the bill does a bit more, so we need to talk about other aspects. A number of the submissions, in fact I think nearly all the submissions from all stakeholders, are critical of the fact that there are no draft regulations being presented at the same time as the draft legislation, and that are essentially a paradigm shift in the animal welfare legislative arrangements in New South Wales should actually require the draft regs be presented for the consideration of the MPs at the same time. Do you concur with that view, that it is essential that the draft regulations be presented at the same time as the draft legislation, and why? If not, why not? I'll start with Ms Flood, if I could.
Thank you. Yes, we do believe they should be presented together. A large portion of the animal welfare requirements and guidelines are included within those regulations, and so without those two presented together, we don't have a complete picture. And when we are looking at some more fundamental changes in terms of the way in which we perceive of animal welfare, it is important that those regulations are brought forward at the same time and have the opportunity to consider those together, so that we have a cohesive piece of legislation and regulation around animal welfare.
Can I just pick up on
Yeah,
one
I've
of
got a follow-up
those
on
things,
that
and I invite everyone to, in their answers, to add to it. So obviously you've got the legislation, you've got the regulation, and then with animal welfare law, you've also got these codes of practice. So wouldn't it also be beneficial to see how those codes of practice may be influenced by what's being proposed in draft legislation and regulation as well?
Yes, so in terms of that, our submission did make reference to the need to include better guidelines on how the codes are updated and how they're brought forward. So that's sort of the administrative side of things, and how they're updated is important. And so because at the moment we have seen quite significant delays with many of the updates to those codes, so we would like to see strengthening within the legislation around that.
And I just to follow on, because it's very similar. I mean, I guess the other concern that we heard a lot around the regulations, we've got 3 acts that were collapsing into one, and a lot of the parts that were initially legislation have now moved into regulation, which don't have the same level of parliamentary oversight. They don't require party room approval to change. And there's concern both from animal protection and from industry around the uncertainty for those to move to regulations. Do you have concerns with legislation, almost large portions of that legislation turning into regulations itself?
Where are we up to? Can I go to the
I think they're all add-ons.
the question of their
yeah.
add-ons?
So if you-
So
yeah.
we'll cascade it. I think it's very difficult to look at this without even seeing what might be the scope of regulations. I don't think this is a futile exercise. I think this is useful. I think there's some really interesting comments throughout submissions, but I just feel like this is a draft, and still needs work in terms of tightening up drafting, in terms of reflecting some of the things that are missing, being more coherent. I don't feel qualified to comment on the issue of bringing the 3 acts together. I think it's maybe doable, but it's not an area that I would have expertise in. In a way, it's like saying the overarching bill is going to be so high level that really everything will be in regs. So I don't know if that's the best outcome or not. The standards and guidelines and codes of practice, I think we certainly need some, if we imagine like the Act's got the high level things, and then we've got the regs which are more species or industry specific, and then within that then we have codes of practice, standards and guidelines. Do we need to see them before? We need to know what they would cover. I don't know that we need that level of detail in order for the Parliament to look at the Act and regs. But I think we need to see the whole framework and see how it fits together, because at the moment I feel like I'm just looking at a few independent clauses about things, and I haven't got any real picture of what this is going to look like in practice.
Yeah, sorry, Nicola.
Oh, I know. I was just going to concur with the points that have been made. I mean, with animal welfare legislation, this is establishing a framework, and it's very much the case that the devil's in the detail. And I think for all stakeholders are going to want to see that detail, and there should be public scrutiny, and from your perspective, parliamentary scrutiny on some of that detail, and particularly when there's provision of exemptions, and as Dr. Goodfellow was explaining, there's no constraint on those exemptions provided in the legislation. There's no criteria that says, you can have these exemptions, but as long as these certain criteria are met. Even in the absence of that, with things being delegated to regulations, it's very concerning.
Yep. Dr. Goodfellow?
Nothing further to add.
I got some very specific cat questions for Ms. Mesk, if that's all right. The RSPCA has suggested in their submission that the minimum holding time for stray cats by charitable organisations be reduced to 8 days for identified cats and 3 days for unidentified cats. I just wanted to get your response to those days and whether that's going to work in practice. And how a shelter actually determines if an animal is stray versus unlost or unmicrochipped. Is that quite a difficult thing to do if we limited it to 3 days?
Yes, is the answer to the last part. Yeah, look, I only saw the RSPCA's submission yesterday, and I wasn't really sure, because I know they make reference to Companion Animals Act and their submission. So it wasn't an area that I had turned my mind to. But to answer your questions, very difficult to establish with a cat, particularly if they're not microchipped. Even when they are, they're often not registered. I think the point they were making was that they wanted to have the capacity to rehome the animals sooner rather than destroy them. But I think those seem very tight timeframes to me. And it kind of depends on what information you have, because sometimes someone's been sort of feeding the cat in this street and they've already made lots of avenues of inquiry to establish whether anyone owns them or not. So when your options are that limited, it's not, I don't think, at all the worst thing in the world to seek to rehome the cat quickly, because it means the cat's spending less time in the shelter. But if none of those inquiries have been made, you know, we know that a cat or dog can hitch a ride in someone's car and end up suburbs away, and you know, at a vet clinic they're taken to, no one knows them, phone numbers change, emails change, you know. I mean, we do need to do a lot more work on getting people to keep their details up to date with registration.
But
Sorry,
it is a requirement to have your cat, dog chipped and registered.
It is.
Part of the ownership. So an unchipped cat is an unowned cat.
Legally. In practice, maybe not. Yeah, it is a very, very difficult area.
I think that's probably more of a comment. I think that probably comes down to personal responsibility in terms of pet ownership, doesn't it? You know, is that something that we want to legislate?
I think that comes under the Companion Animals Act, and so we're sort of getting a little bit off topic, but I also want to get your thoughts quickly on Section 30 of the bill, where it's an offence of poisoning a domestic animal. Do you think the provision goes far enough to protect animals, particularly cats, from intentional or accidental poisoning? I often get a lot of calls from my office that a cat or a dog has died after consuming 1080 poison, mostly where someone has not necessarily intended to kill them, but they've just been a bit reckless as to where they've placed that poison, haven't told the neighbours that they've put it out. Do you think that they should be liable under the Act if they've accidentally and recklessly put 1080 and it's poisoned a domestic
I'd like
animal?
to see 1080 banned. But yeah, look, I was also, I can't remember whether we said it or not, but I know it was raised with me about, you know, birds and other animals as well. The placing of poison is a really scary thing for animals, for children, you know, for people who might walk through it or whatever. I think it has to be done with so much caution, advertising to let people know it's happening, if it's to be done at all. It's a dangerous practice, so not comfortable with it.
Okay, that's all right. I might move on to the minimum care requirements. The legislation focuses on minimum care requirements throughout the bill, focusing on the bare minimum people should be doing for animals. Dr. Goodfellow, do you think that that's the best approach, this whole idea of minimum care requirements?
That was one aspect of the bill that we thought was drafted well in terms of the list of minimum care requirements there. I mean, other state and territory animal welfare laws around the country will frame it as the duty of care, you know, and that may be a better way to frame the duties, but as long as the duties are there and they're providing for good animal welfare outcomes, I think that's the most important thing. But that was one aspect of the bill we thought was done well.
Strong, okay.
So, Mr. Benasiak.
Yeah, sure. I might just go to a point you made, Ms. Flood, in your opening statement about wanting to see a separate court for animal offences. I think as legislators, we always, when we're making amendments, we're looking at, well, what is the problem we're actually trying to fix or address, and is our solution the best way of fixing it? And your point about having low sentences, I think could be not just attributed to animal welfare offences, but just offences in general that end up in court. I think it's quite often put to us that magistrates get it wrong in terms of sentencing. So is a separate court the best solution, or is it more about better education to magistrates and judges about the importance of animal welfare and the importance of, sentencing appropriately?
I think education is a good backup option. However, given the very technical nature of animal welfare issues, having a separate and dedicated court would be beneficial, because so we've got an example currently with the Land and Environment Court where you have dedicated judges and commissioners who come from particular backgrounds who have a skill set that is relevant for that area of law. We could again look to that with animal welfare, with people who have veterinary backgrounds or people who understand the implications for the animals of failure to care for them correctly.
Try to quickly, if with the indulgence, go to, I think everyone I don't think the Cat Protection Society mentioned it, but the others have certainly, about this concept of an independent statutory authority rather than having the charities. Reading the tea leaves a bit, it doesn't look like the government is probably going to go that way. In the absence of that, what was raised in the discussion paper was that you broaden the number of organisations beyond RSPCA and Animal Welfare League to do that work. Is that something that your organisations would be considering putting their hand up for if that independent statutory body doesn't get up?
I assume that the Humane Society International would not be seeking to have an enforcement role under the legislation. I would just add that we did include a recommendation in our submission, though, that standing to bring prosecutions under the Act, well, not prosecutions, but civil proceedings under the Act be extended, similar to what happens in environmental protection regime and also consumer law as well, where there can be certain criteria to allow private litigants to provide an additional source of oversight through applying the legislation, but in a civil context, but yeah, not in an enforcement sense.
Can I just clarify as well, just because I noticed that the question was an independent office of animal protection instead of the charities enforcement. Is that what the groups are actually submitting?
No.
Okay.
So we would like to see an animal welfare authority established in order to administer the legislation. The enforcement of the legislation, though, could still be conducted by the bodies that are in existence right now, but instead of answering to the Department of Primary Industries, they would be reporting to the Animal Welfare Authority as a centralised agency. And we think that would really fit well with the consolidation of 3 different pieces of legislation as well. Animal welfare regulation is becoming a lot more complex these days, a lot more sophisticated. A lot of expertise and specialisation is required, and having a central expert authority set up to administer many of those regulations would be a great benefit to the...
So could I just ask on that then? So there were a lot of submissions that looked at the idea of an independent office of animal welfare, and it's a concept that's been talked about for decades. There are sort of different ways of structuring that. In your view, do you see it as being primarily about, I guess, overseeing the effectiveness of the laws, or would you see it as having also a role in advocating, for example, it's a recent example with the floods, would it be advocating for how we plan better for animal welfare during a disaster, or would you see it as having a broader role than just overseeing, the effectiveness of the legislation?
Yeah, so there's really two different kinds of models. One being an authority that would be recognised, established by the legislation, that would perform those administrative and regulatory roles and administer the legislation generally. The other option is some kind of animal welfare commission or office that would provide policy advice to government, may have some kind of advocacy role for animal welfare within the jurisdiction. The way we can see it working is to have a national animal welfare commission, as the Productivity Commission recommended in 2016, that would provide that leadership and coordination for the states setting national standards. But at a state level, we would have independent animal welfare authorities that would provide that administrative function, and that seems to be would be logical in terms of that demarcation between those different roles.
Ms Flood, did you want to
Yes, if I
talk about
can.
that as well?
Just in response to your question around the handling of animals in disasters, as we've seen recently with the Northern Rivers floods, we do think there is a role for a peak body such as an independent office of animal welfare to help not only with the managing and overseeing responses, because while we haven't had a formal inquiry yet, the evacuation of animals in the Northern Rivers did seem to be very ad hoc. There didn't seem to be much planning in place, and we think an independent office could certainly help advocate for animals in disasters and help ensure that they have adequate plans in place, not only to respond when there is a disaster, but to also look at more broad-ranging reforms around the positioning of where intensive farming should be. For example, we're getting to a point where we may need to be looking at whether we have intensive farming in those sort of floodplain zones. We're having those conversations now about townships, and an independent office of animal welfare could be responsible for looking at any of those sort of reform opportunities.
Thank you.
A question from Mick Veitch.
Thank you very much. Again, moving on to another area, not all of, some of the submissions, and in fact, I think some of our officers are now receiving email and telephone approaches from constituents concerned that this legislation, legislative framework, introduces a licensing arrangement for animal research and exhibited animals. The concern, and I opened the Chimmet show last Saturday, and it was raised with me there in the Chook Pavilion. The concern is we're now going to require licensing for animal exhibits at agricultural shows. As I understand it, that's not the intent of that arrangement. Is that your understanding? Because if it's not the case, I want to put that bushfire out straight away.
I didn't think that was the intention. I noticed that with one of the cat fancier submissions as well, that I didn't think it covered things that it didn't used to cover. They weren't covered before, and I didn't see them being covered now.
Is there a definition of exhibited?
I'm sure there is. I don't know it off the top of my head.
I think Scott's got the bill.
This might be
I thought
one.
it would have
I thought
applied
it
to
would be covered.
circuses rather than...
Yes.
This might be one of
Imagine that's
those.
the intent, yeah.
Yeah.
So
The
that
intent
was
was...
Okay, we'll
bring
look
things
into
like
that.
zoos.
Okay, look, with just a few minutes left, was there a member that... Oh, it was his.
I just might ask you quickly, Ms Flood, if that's okay. World Animal Protection Index, is that an index that your organisation develops?
Yes, so the Animal Protection Index has been around now for quite a number of years, and it looks at ranking countries globally around their animal welfare laws. So it looks at a number of things, including recognition of sentience and the guidelines around how animals should be treated. I'm happy to provide more information to you on that if that would be beneficial. I can provide some background.
But it's an index developed by World Animal Protection.
Yes, that is correct.
How does Australia rank? You talk about the D there for Australia. How does that rank against US?
Against the US, I would have to take that on notice and cross-check our information. I can come back to you on our comparison to the US.
And Canada and China, please.
Canada and China as well. Yes, I will come back to you. Thank you.
Thank you very much. Look, we've only got a couple of minutes, and I'm really keen that if each of the witnesses have an opportunity, if they feel that we've missed something or something important that you wanted. I'm not asking for a summary, I'm just asking if something you think has been missed, please use this opportunity to bring it up. I might start with Ms Flood.
Thank you for the opportunity. There's nothing in particular that has been missed.
Thank you. Ms Besk?
Thank you. And
Comfortable with-
it's so enormous, but it's been wonderful to have some discussion, and I know you're going to be having a lot more over the next few days, so thank you.
Thank you.
Just quickly on the point of sentience, we talked about how New Zealand and the EU and the ACT have recognised sentience, but I did want to draw the committee's attention to the fact that also Chile, Colombia, Peru, Tanzania, Quebec, as examples of other jurisdictions that have recognised sentience, and the UK, given that they've left the EU, also has a bill to recognise animal sentience going through its parliament at the moment. And the EU Free Trade Agreement, I think we can be fairly certain that they will include that recognition of sentience because it's mandated in the EU that has to be done. So I think it is. I just wanted to convey that it is where the benchmark for modern animal welfare is set, is having that recognition.
Thank you.
Yeah, we have an appendix at the end of our submission that lists all the different countries and jurisdictions that are recognised sentient. So there's a current count. There's 19 of them around the world, and there's more on the way. So. But I had nothing further. Thank you very much.
Mr. Goodfellow, may I just ask you to clarify one thing? You referred to a productivity report,
Yes.
session report. I was just wondering if you could provide us with those details.
Yes, absolutely.
Can I get one more question if we've got time? Sorry, I just have a question for Dr. Goodfellow. One of the submissions that we received wanted a new law to make it mandatory that anyone with evidence of animal cruelty report and supply that evidence within a 48-hour time frame. I wanted to get your thoughts on that proposal and whether it would actually have a silencing effect on people reporting cruelty.
Yeah, this was debated extensively at the national level. There was a bill proposed a number of years ago with that requirement, and it raised a number of concerns for a lot of different organisations and sectors, really based around the sort of onerous requirements there, what it would capture, and also, yes, the idea that it could potentially prevent people from reporting cruelty if they were not aware of the 48-hour reporting timeline and then found that they had missed that, and therefore would they be guilty of an offence if they haven't reported it within 2 days. So we think certainly it's an onerous and really practically unworkable proposal.
Thank you.
Thank you very much. And my colleague, Mr. Mark Buttigieg, I don't think you have anything further.
I'm all good, Chair. Thank you very much for asking.
Thank you so much. Yeah, that's very much appreciated. Okay. I would thank everyone, all of the witnesses, for attending this hearing. A couple of questions have been taken on notice, and the Secretariat will contact you in relation to the questions that have been taken on notice. So thank you.
Thank you.
Thanks very much.
I'll welcome our next witnesses. We have a panel of 3. We have Ms. Fiona Chisholm, who's the New South Wales State Director for the Coalition for the Protection of Greyhounds. And we have on WebEx, we have Ms. Uges and Ms. Hamad, representing Animals Australia. So, could each witness please state their name and position and title and swear an oath or affirmation? And I will begin with Ms. Chisholm. Welcome.
Thank you. My name is Fiona Chisholm. I'm the New South Wales Director for CPG, the Coalition for the Protection of Greyhounds, and I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Ms. Uges.
Thank you. My name's Glenys Uges. I'm the Chief Executive Officer of Animals Australia and appearing here for Animals Australia. I'll take the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. Thank you.
Thank you. Ms. Hamad.
Thank you. Good morning, panel members. My name is Shartha Hamadi. I'm Legal Counsel at Animals Australia, and I'll take the oath. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And I apologise for any mispronunciations I made, so that's assisted me as well. Thank you.
That's fine.
I invite the witnesses to each make a short opening statement, and please keep it to no more than a couple of minutes. We have 45 minutes for this session, and the members will attempt to cooperatively and collaboratively ask you questions, and then right at the end, I will give each of you an opportunity if you feel something important has been missed. So I'm hoping to make time available at the end for that, not to make a summary, but just simply if you think there was something the inquiry didn't get. Thank you. Ms. Chisholm, can I start with you? Thank you.
Thank you. We were advised we had 3 minutes, so this addresses that length.
Thank you.
The CPG, the Coalition for the Protection of Greyhounds, is a dedicated group across volunteers across Australia and overseas who work together to inform the public about the cruelties of greyhound racing. What I'd like to highlight today about the Animal Welfare Bill, especially for the Labor members of this committee, is the New South Wales Government's ill-considered decision to remove a banned procedure from the bill due to pressure from the greyhound racing industry. This procedure is the surgical artificial insemination of dogs. I'll now refer to this procedure as SAI for brevity. SAI involves cutting through the skin and muscle to reach the uterus and injecting frozen or fresh semen there. Then the female must carry the pups to term, having just had gut surgery. Because of this, SAI has been banned in Norway for 30 years, and the UK and Sweden and Denmark for many years. As the RSPCA says on its website, surgical AI is highly invasive and causes significant pain to the female dog. There are now two widely used alternatives to SAI. Those are Transvaginal and Cervical AI. Monash Vet Clinic is the biggest reproductive vet clinic in Victoria, and it says on its website, Cervical insemination is a superior method of insemination to surgical insemination. With TCI, there is no need for the bitch to undergo an anaesthetic. There is no surgery. With TCI, the bitch stands on the table and we use an endoscope and specially designed catheter to deposit the semen into the uterus of the bitch. The Independent Australian Vet Association Sentient says, there is no evidence base to support the greyhound industry's view of surgical AI as being superior. To continue using surgical AI on greyhounds is unethical because the surgery involved is not necessary for the health and welfare of the dogs concerned. So, by caving into the old-fashioned approach of the greyhound industry, the Minister has also left thousands of other dogs in New South Wales puppy mills vulnerable to the cruelty of SAI. He's also made a unilateral decision before this committee even concluded its review process. The issue for Labor members of this committee is whether they think this is acceptable or not. And finally, given one of the main objects of the draft bill is to prevent cruelty to animals, there is no way that the ban on SAI should be removed. Thank you.
Thank you. I'm not sure who from Animals Australia wishes to... Is it Ms Hamadi?
Ms Ujuz will be speaking on our behalf. Thank you.
Thank you.
Thank you, Chair. Speaking on, on behalf of both of us, we thank you, of course, for the opportunity to appear today. And it's a really important issue. At its heart, it deals, of course, with the everyday lives and protection of the animals in our care, in our human care. Sadly, though, the draft Animal Welfare Bill that is before us and before you will not do that. The bill hints at reform with such advances such as the coverage of cephalopods and decapods and recognising explicitly now that psychological suffering is also harm, and even indicating the obligation to provide animals with appropriate opportunities to express their normal behaviours and to provide their behavioural needs. Whilst these things are welcome, it should be conceded that these concepts are not new. Indeed, the freedom to express normal behaviour for animals was one of the so-called 5 freedoms stated in the UK Bramble Report almost 60 years ago. But worse than this inordinate delay in legal recognition of this freedom is that the bill before you, and indeed the current Prevention of Cruelty to Animals Act, then immediately rules out even the basic freedom for whole classes of animals in our care, in particular behavioural freedoms for farmed animals. The Act and the new bill accept roles of codes, standards and guidelines as virtual exemptions from the cruelty provisions of the law. These documents are what I call the gap. They allow millions of farmed animals in New South Wales to be subjected to harmful and cruel procedures with impunity, some of which should have been phased out decades ago. Things such as painful mulesing, dehorning of cattle, crowded, barren poultry sheds, intensive confinement such as farrowing crates for pigs and battery cage hens are just examples. Similarly, Section 13.2 in the new bill states in its minimum care section that an animal is to be provided with appropriate opportunities to exercise. But wait, if the animal happens to be a stock animal, this does not apply. Stock animals being, as you probably know, including cattle, sheep, goats and poultry, the vast majority of the farmed animals that reside in New South Wales. We must also ensure you're aware of the flawed review processes for codes and standards and guidelines. It's biased and incredibly slow process. An example, the poultry standards have already been in the current review process for 7 years, and I've been involved in that process and still are. But it seems that even when that document emerges and is adopted by ministers, it may allow the caging in barren or wire cages of battery hens until at least 2036. By the way, this is 24 years after they're actually banned, after a phase-out period in Europe. Scientifically backed ban. The current New South Wales Act and Bill are cut from the same cloth in our view, despite the passage of the past 4 decades. Throughout that time, the evolution of community concern for animals and a wealth of animal welfare science has occurred. The bill even shirks the opportunity to introduce the inclusive word sentient to describe the very animals it seeks to protect. This failure too has caused us to lose confidence that this proposed New South Wales bill and its future influence and enforcement will fall far short of its stated objects that are to promote the welfare of animals and to prevent cruelty. The bill in its current form will continue to allow housing and handling conditions that the people of New South Wales would want to avert their eyes from, where they see and hear the suffering of those animals. We all share the responsibility of caring for the vulnerable, and now you, the committee members and the New South Wales Parliament, have within your grasp a once-in-a-generation opportunity to dismantle age-old policies that lead to unthinking and routine treatment of animals that cause suffering, both physical and mental suffering. We urge you to reject this bill and instead resolve to protect all animals with modern and equitable law. Thank you.
Thank you. Ms Emma Hurst.
Thank you, Chair. I might start with greyhounds, and then I think we can sort of move on to the much more broader issues discussed by Animals Australia. Thank you for coming today. Yesterday, the Minister suggested to me publicly in budget estimates that the ban on SAI was not necessary because the procedures regulated by the Greyhound Welfare and Integrity Commission. Could I get your response to that?
Yes. First up, the procedure's not banned under the Greyhound Racing Act, so that's a complete misdirection. And currently, GWIC's Guide to Breeders states that the TCI method is as effective as surgical AI, if not more so. And it's very clear from all the vet science published research that TCI is. And sticking with SAI is really old-fashioned and behind the times and just pushes Australia further down the global rankings on animal welfare behind countries like Mexico, which is hard to believe.
Can I just pick up on this point? So why is it that it takes place then? Why does it still happen if there are far superior non-surgical methods? Why is it?
Inertia.
People are just used to it. It's been happening for decades. They just do it routinely.
Yeah. You can look at the research online. It's available there for anyone to see. Extensive research about the fact that TCI is just as effective. There is only one reason that you would do SAI, and that's why the veterinary groups have, in some cases, suggested it be a restricted procedure rather than a banned procedure. And that would be only in the situation where a vet advised or decided that medical surgical AI was necessary because of some problem a dog had. But that would be, a rare exception.
Yeah.
And the problem is policing are restricted. It's very difficult, you know. Sentient, the Independent Vet Association, made the good point that you would need to be able to monitor that situation so that vets who were doing a restrictive procedure too often were picked up.
Yeah, okay, thank you.
The TCI you talk about, is it like how new or when has it been developed?
Been around for years.
And these sort of procedures, I guess, are continually improving and things are becoming outdated and that sort of stuff.
Absolutely.
Does that not point to the fact that these things then should sit in regulations rather than the Act itself, meaning that as, you know, new things evolve, they can be picked up in the regulations without having to rework the legislation itself?
Look, I think that's a question for the lawyers, but the bottom line is the experts that put together this bill for you ranked SAI as bad, as a ban procedure, as hot face branding of animals and tail necking of horses. Do you know what that involves?
Yep.
Okay, so, you know, the experts who put the bill together, who are also being ignored, as well as the RSPCA and all of the vet science experts, they ranked it up there on that level with hot face branding of animals. That's how cruel it is. We are so behind the times.
So, sorry, other witnesses have suggested that we actually need to include in the bill a list of prohibited activities, which might give greater clarity in that sense. Is that?
Well, it is, SAI was proposed as a prohibited activity, but yesterday it was confirmed and your Minister for Agriculture has written to Greyhound New South Wales saying he will remove it. He will remove the ban. This will take us back to a situation that we might as well be back in the 60s and 70s. When are our legislators going to wake up about the fact that the Australian population wants better animal welfare protection? And you're losing votes because of it.
Can I?
Parties that we've... All the research on public opinion shows that the Australian public, the vast majority of the Australian public, is not with you on animal welfare. They want better protection.
Can I ask a couple of specific questions from submissions that we received from the industry?
Sure.
So they have said that the industry should be exempt from other provisions that are also proposed in this bill. So they want to be, for example, they want to be exempt from the provision around live baiting and the ban of live baiting. They argue that they don't need the ban in Section 33 on live baiting because current regulations are sufficient. Do you have a response to that?
Well, yeah, my actual response would be unrepeatable in public, but look, how much taxpayers' money was spent on the McHugh inquiry? The millions of money that it took for the then government to fix up the mess that Greyhound Racing New South Wales had created in this state. That cost us as taxpayers megabucks. That came out of public pocket. And now they're saying that they should be able to keep doing it again after all the evidence was presented on four corners?
Even from what you just said, that's not what they're saying. They're not saying that they should be allowed to do it. Is that?
Sorry, so the question is specifically that they want to be exempt from the live baiting provision in this bill.
That it goes into the regulation?
No.
Sorry, I'm just going back to what you said.
Sorry,
whatever way it's exempt, it's obscene.
I just don't think the greyhound racing industry is saying that they should be allowed to...
No, they're saying that the current regulations in the Greyhound Racing Act and Code are enough and that want to be excluded from the Animal Welfare Bill provision.
So they're not saying they should be allowed to use live baiting?
So I think what they're...
Well, they're loosening it. They're saying they don't
just
want to
try
be in the
and
Animal
loosen it up.
Welfare Bill and that they would rather just be in the Racing Code and not have any restrictions or provisions in the Animal Welfare.
It's not subject to the same parliamentary
Yeah.
scrutiny, etc. Could I
jump in, please?
Can I ask about some of the other recommendations that you've made in your submission, Ms. Chisholm? One of the ones that we heard a lot about during our select inquiry into animal cruelty laws was in relation to the idea of allowing third parties to bring public interest legal proceedings. Can you talk us around sort of why you feel so strongly that that's one of the key reforms we should have in here?
Yes, it's really, really important that that freedom exists, much as it would in any other realm of affairs in a democracy, so that when official organisations and authorities are constrained by either virtue of the funding they depend on or other political reasons, that third parties can then step forward and do that. And this trend would follow trends that we've seen in the Northern Hemisphere, where that provision exists and has given a lot more freedom for cases to be brought. Yeah.
Do you believe that there are, at the moment, offences that are going unprosecuted because of a lack of resources, or perhaps because of a lack of prioritisation from those entities that are entitled under the law at the moment to prosecute?
Yes, I think one of the best examples of this is the New South regulator, GWIC, which does the best possible job it can with the resources available. Groups like ours would always like to see them do more, but they're a regulator and they get bashed from all sides. That's the nature of working in a regulator. But the key thing is, this government failed to empower GWIC to track New South Wales greyhounds when they're shipped across the border. Now, the problem with this is exactly analogous to the situation that existed way back in the days when there was no national securities legislation and white-collar crooks could just go across the border, start up again, and start misbehaving and ripping off members of the public. Now, you're well aware this is analogous with puppy farms as well. As soon as Victoria brought in the more serious legislation, they racked off over and set up in New South Wales. So we've estimated and published and substantiated, and GWIC subsequently substantiated, there are about 2,000 and more greyhounds that are unaccounted for. Basically, when they move across the state border, they're not tracked anymore. GWIC isn't allowed to. Now, you've got to ask why. Why aren't they allowed to track those greyhounds? If, as the industry says, they love their dogs and they're concerned about them and what happens to them, why don't they track them when they go across the border?
I just want to very quickly follow up, if I can, Abigail. Third-party prosecutions, the bringing of third-party prosecutions, Ms Chisholm, is there a jurisdiction that does this well that we could look at, the framework upon which they do that?
Oh, look, I think you'd look at the Northern Hemisphere, definitely. Yep.
And why? I guess the next question is: so why does that work well? What provisions do they have that make it work well?
Well, the mere fact, I think, at this stage that third parties can bring those actions is important, because it means that an organisation, say an organisation like the RSPCA that needs to depend on funding from government, it has to be politic about it, what it does and when. It's very difficult for them to bring every action they'd like to. Also, the draconian rules around listening and surveillance legislation, if third parties were empowered to bring actions and those draconian restrictions, especially in New South Wales, didn't apply so that they were empowered to bring those actions, then animal welfare would be able to be protected much better than it is. And I would cite as an example of that the restriction on the prosecution of those who were clearly guilty for mistreatment of greyhounds and other animals due to live baiting. And I think we're all aware of that went all the way to the Supreme Court, but because of the draconian nature of the rules around surveillance, it impeded the ability to take that forward to where it should have been taken. So if third parties were empowered to pursue this the way they are in the Northern Hemisphere, they would also be empowered to take actions that freed them from some of those draconian restrictions.
Right, thank you. Thanks, Abigail.
Should we?
I've actually got a few questions for Ms. Hamadi and Ms. Uges. Thank you. It's been argued in a few of the submissions that some industry groups from some industry groups that the DPI should be solely responsible for enforcing animal cruelty laws in relation to farm animals. And I wanted to get your thoughts around that as a model, and if you don't agree with it, what model you think we should be using.
Thank you. Ms. Hamadi might have something to add, but what I'd say at the outset is that we don't believe that model has or will work for us. I mean, clearly at the present time that is the case, but the Department of Primary Industry, and it's similar in each of the states, of course, is its primary purpose, if you like, is to increase productivity, profitability, and to enhance animal agricultural and farmer returns. And often that is in conflict with animal welfare. When I say that, clearly changes and reform of the way we treat animals may in some cases mean the need for increased infrastructure and higher costs of the production. If you're going to provide better welfare conditions for animals, it may cost more. And that's something the community, of course, is supportive of. But clearly the farmers have not, and therefore the agriculture ministers, the current, past, and the state colleagues of the agriculture ministers have over and over again shown that they are not going to be progressive in adopting scientifically based animal welfare reform. Now, that goes to enforcement as well, of course, because there's a bias there. So our model, we do not believe that the DPI should be the ones administering the Animal Welfare Act in New South Wales. What we suggest differently is that there be an Animal Welfare Commission or something similar to that. It was suggested and recommended by the Productivity Commission some years ago that there be an independent approach to both the setting of standards, but also then oversight of the enforcement or compliance elements of any act that's put into place. We would suggest that it be under a minister and in a department that is independent of agriculture. I'm not sure, Shartha, if you'd like to add anything to that, but certainly we see a completely independent approach to animal welfare is so important if we're going to actually provide animals with the protection that they are owed and we are obligated to provide.
Thank you, Glenys. I have nothing further to add.
Abigail, I think you wanted to follow up.
Yeah, could I ask sort of slightly different topic, I guess. I'm just, I'm aware that as a Australia-wide organisation, you've got information on all of the different states and territories in Australia. I do hear a lot that New South Wales is particularly outdated in its animal welfare laws. Can you tell us, I guess, how true that is and which jurisdictions we really should be trying to model?
Or beat.
Yeah, or beat.
Thank you. I would say that with the exception of the Australian Capital Territory, which has recognised sentience and banned a number of particularly intensive farming practices such as battery caging and sow stalls, for example, for pigs. But as in essence, each of the current state animal welfare acts and their similar acts do not provide good protection for many classes of animals, and it's not just farm animals. Also, what's allowed to be done, for example, to introduced species, to fish that are exempted often. There are real large categories of animals that are exempted from the real protection of the cruelty provisions of each of the acts. Having said that, some states are moving to improve their act. Victoria, as you probably know, is under review at the moment, and the current government there has suggested that they are going to explicitly recognise and insert sentience as an element of their act. So there are changes coming in some states. But in my opening statement, I talked about particularly the exemption for codes and now called standards and guidelines that themselves are so backwards, so steeped in 1950s, 60s practices that is a real problem. So I guess my answer is I can't, apart from the Australian Capital Territory, I can't suggest one to you. But what I would say is looking at our neighbours in New Zealand would give you a very good indication of what's required in the Basic Act, and then the review processes that are in place and are currently developing in order to improve practices.
And in terms of the structure of our legislation, where we have, sort of the main act, and then we have multiple regulations, and then sitting under the regulations, we've got increasingly sort of non-reviewable instruments, codes, conduct, etc., that can sit like that for decades without ever being reviewed. Is that a similar structure applied in other jurisdictions, or do other jurisdictions do better at ensuring that there's not as much discretion in the detail and that Parliament has more of an oversight?
Shartha, you might be able to help here, but particularly in New Zealand, for example, the way they go about reviewing the standards that are then adopted virtually as regulations is a much better, cleaner process with eventually going to the Parliament, of course, but based on scientific evidence. And so I would point there. Certainly you could then look overseas, and you'd be looking at the UK and to Europe for a better system.
Thank you.
Can I, you talk about, or you've campaigned for many, many years about certain animal husbandry procedures that are allowed in New South Wales, things like mulesing, branding, castration, dehorning, tail docking, often without pain relief, and you've campaigned quite heavily to have these outlawed. Why do you think these procedures should be outlawed, and how would a change in these laws work in practice?
They need to be outlawed because they cause great harm and suffering to the animals involved. And as you say, in the most cases, there is, even though in more recent years there's been pain relief that's not expensive nor difficult to administer, that has been developed, and yet pain relief is not a requirement under the law. So certainly I think that if we're going to look after animals, we have to use the best practices available, and that's not the case at the present time, and there's no legal recourse if they don't use those better practices. So I do think that that's been an outcome of the flawed review of codes and standards and guidelines. And again, that comes back to the very fact that while those codes and standards are said to represent scientific evidence, community view, and industry practicalities, it's only that last one that is taken into account. And when I say practicalities, it really just means that they're not ready to move. Often there are alternatives, such as pain relief, of course, but also, even if, let's focus on mulesing just as one example, there are farmers that have already been able to move away from mulesing, and if genetic change, breeding, selective breeding, such for a smooth breech, that is possible. That is possible with just a few years, sometimes up to 5 years of breeding focus, and yet it's not been incentivised, it's not happened, and we still have these terrible situation where literally millions of lambs are mulesed without any pain relief, and you have to deal with the pain of that wound for weeks, if not up to a month. It is quite disgusting.
With that in mind, obviously there's an enormous amount of exemptions in this Act for what are considered normal husbandry practices. Do you feel that these exemptions for farmed animals in the bill are appropriate for a modern animal welfare bill? And I'd just like to get, a general statement from you about those exemptions and what changes you would recommend.
The exemptions are not appropriate, and I suggest that they debase the bill. They debase the objects of the bill, that is to prevent cruelty and to protect animal welfare.
Can I just add to Glenys's comment? It's really disappointing and really frustrating that in 2022, we're sitting in a parliamentary hearing debating and discussing questions around whether or not we should be using pain relief on animals as a result of removing their teeth, their tails, their horns, etc., castrating them. In 2022, we are still asking the question and looking to science around whether or not we should be administering pain relief. This is why the community is fed up, and this is why the community, I can only echo the powerful sentiment of Ms. Chisholm earlier. The community is fed up, and we're fed up of having these conversations. We have been going around in circles for decades about codes of practice that were set in the 80s and 90s to codify farming practices to secure producer interests so that they can escape cruelty provisions under the Animal Welfare Act, the legislation in this state, in this country, that was put in place by the Parliament to protect animals. The fact that we carved them out in the 80s and 90s to continue industrial farming practices is one thing. But for us to be sitting here in 2022 and still asking the same questions we were asking ourselves 10 years ago, 20 years ago, we are really fed up and tired. And we were really hoping that this legislation was going to be progressive and was going to listen to the community sentiment. You need only look at the purchasing behaviours of the community around better farming practices. It is increasing. People are making kinder, more compassionate choices. They're not waiting for the science to catch up to the legislation. They're acting on compassion and kindness and what they know to be truth. And so I'm really sorry, but this is a tired conversation. The pain relief is there. What was necessary and justifiable harm in the 80s, in the 90s, in the early thousands is no longer necessary and justifiable. It's 2022. The pain relief is there. The community has spoken. You've received thousands of submissions. We can split hairs around this, but it's time. It's time for us to progress. It's time for us to do better. Now, we can sit here and we can carve up this bill around prosecutions and sentencing and sentient, etc. But I think from the thousands of submissions that you've received and the purchasing behaviours of consumers and the community, and in fact the global community, we need to do better. We need to do better, and we can do better.
Here.
Ms. Hamadi, can you give us some of those top major changes that you are hoping to see in the bill that are clearly missing?
Look, we're not saying that overnight factory farming must cease. What we are saying is there is nothing progressive about our laws, our codes and our standards. New Zealand has got progressive clauses in their codes and standards, enforceable, not discretionary, not voluntary, where they say within 10 years, within 5 years, within 7 years, certain industrial practices which do not accord with the community sentiment must be phased out. They are doing better. They are progressive and they are looking to the future. We seem to be stuck in the past and we seem to be bowing to a fear around recognising the sentience of animals. I mean, what's wrong with us? Of course they're sentient. The pain relief is there, the better farming practices are there, and I'm sorry, again, the community is fed up and we are fed up with these processes. We really know the truth around this. We can do better. It's available, and I think we really need to dig deep and go there.
Ms. Soudges, you talked a little bit before as well about the inclusion of cephalopods and declipod crustaceans in this bill and including them as animals. We've received submissions from industry that are debating whether or not these animals should be included and recognised as animals. Could I get your reaction to this? And also if there's any scientific basis that you're aware of to argue that these animals are in fact not animals.
Well, of course they're animals. The question is whether or not they can experience pain and suffering, and that includes, of course, distress. And that is, the science is there. I can't quote it to you right now, but of course, when that was being put together, and in other countries, of course, as well, the science indicated that they would react to painful stimuli, for example, and that they had social connections and such things, such that it is very clear that if you're doing something to them that restricts or harms them or injures them, that they are going to feel the effects of that. And that's why they've been included in the Act, quite rightly.
Thank you. I have quite a specific question. Just because I know I used to work for an animal protection organisation as well, and something that we always got called about was animals that were tethered 24/7, and the difficulties for enforcement agencies to actually act on that. This legislation does suggest some very mild changes to tethering laws, but again, I mean, like having a look at it, whether the changes are enough to help get that enforcement. I wondered if you have experienced the same complaints and what we need to do around that space of tethering animals.
But can I say that it's a very, as you know, and the reason is twofold. That is, it's a very risky thing to tether an animal because they can become entangled and have difficulty getting to food and water, for example, particularly water. But also, apart from that risk is the lack of exercise, if you like. And as I just indicated before, stock animals, and of course the tethering of goats, for example, they don't even need to have further exercise as such under the exemption that's suggested there. So, but in regard to complaints, we have on occasions complaints, but they are primarily would be directed to, and most complaints would go to the RSPCA. In order to try to relieve the suffering of animals that people have observed. The sad part is, of course, that outside people are not necessarily going to observe these situations because the tethering may well occur in the midst of a property where there's no other eyes on the animals. So tethering just should be banned.
Thank you. Also, puppy farming has been neglected from the bill. Obviously, there's been a lot of discussion around puppy farming. You're in Victoria, where I believe puppy farming has effectively been outlawed. Do you think that that's an oversight in this bill, that puppy farming should have been identified as well?
Yes, certainly. We are pleased that it's been now explicitly indicated that psychological suffering is also harm to an animal, and so that may assist to some extent if you get down to the situation of a complaint and therefore a prosecution. But yeah, we really are concerned because this is puppy farming. We absolutely oppose puppy farming because of the effect on animals that are kept in an industrial way, that is, rather than being born and raised in a household, which is where you would expect them to eventually go, they start in an impoverished environment, and so we absolutely oppose puppy farming. We do, though, think that breeding itself, dog breeding, should, and cat breeding for that matter, should be something that is regulated so that indeed a better environment for the animals is provided. And we certainly would think that the Victorian legislation is a start, but it actually doesn't go far enough. It allows, for example, up to 50 breeding bitches to be kept in a particular puppy farm as such. There's no way that those animals, those dogs and their pups, can be properly enriched through the important period of their lives when they're on the farm. So, yeah, we do think it's an oversight and it has to be addressed in some way.
Thanks, Ms. Uchus. I just got one question before we wrap up. It's to both panel participants. Most of the submissions are critical of the fact that the regulations or draft regulations are not being considered at the same time as the draft legislation. Do you think that should be the case, that the draft regulations should be presented at the same time for consideration in the Parliament as the bill? And I know Mr Banasiak earlier asked, should that also include the potential codes of practice as well, so that the legislators actually have the full picture. Ms Chisholm, if I could start with you and then we'll go to Mr Woodges.
Yes, I think that in the development of any legislation, having worked in a regulatory body for 5 years, the fuller picture that your legal eagles can have when such material is being developed, the better. It's just having oversight of regs in addition to the actual Black Letter Act allows you to look for where there might be conflict, for example, or where there might be problems that arise and you get an echo that's problematic. So, yeah, it's just common sense where that's possible.
Okay, thank you. Ms Woodges?
Oh, look, we agree that you really do need to have an indication of what the regulations are likely to do and some indication that they're not going to undermine the Act itself. But in saying that, I would go back to the Act at the present time and the bill as it is at the moment, the criticism that we've suggested. At the moment, it does indicate that codes, standards and guidelines, as most of them are now called, and regulations are going to undermine the objects of this Act, that is the prevention of cruelty and the protection of animals, will not occur given what we've already seen in the bill. So while, yes, thank you, of course, your question is important, I think that it is not the key issue that is of concern at the present time.
So we have 2 minutes left. I want to thank all of the witnesses and give each of you the opportunity, if you feel that we've missed something or something important hasn't been said, to make that statement. So Ms Hamadi, can I begin with you?
There's nothing further for me. I think I made my point quite clear.
You
Thank
did.
you.
It was powerful evidence and I thank you for it. Yeah. Ms Woodges?
No, similarly, I'd only be repeating what we've already been talking about, the carving out of huge classes of animals and causing suffering to them.
Thank you. And Ms Chisholm?
Thank you. The question from this side of the table, which I really appreciated because it was a genuine question about why the situation is as it is. I just wanted to let you know that inertia doesn't just apply to the people in the industry. It also applies to the veterinary profession. And again, the RSPCA has had so much material about all of this on the public record for some time. And they said unwillingness of some vets to acquire the skills or equipment to undertake transcervical artificial insemination is an insufficient justification for permitting the unnecessary procedure where expert opinion within the profession confirms it's outdated. So it's not just the industry, it's also some parts of the vet profession. Mind you, I should say, not a large part. Most of them are good scientists and will tell you very readily that SAI is old hat.
Thank you so much. Look, I want to thank each of the witnesses for attending and for your evidence today. The Secretariat will contact you in relation to any questions that have been taken on notice. I'm not sure that there were any.
No.
But I really want to thank you for the evidence and also for your written submissions as well. It's greatly appreciated. Thank you.
Thank you.
Thank you very much.
Thank you.
Just have a short intermission while we organise our next witnesses. Thank you. Welcome our new witnesses. Mr Craig Golding, who's the Director of Shooters Union New South Wales, and Mr Makem, who's Vice President of the Australian Pig Doggers and Hunters Association. So, gentlemen, could each of you please state your name, position, title and swear either an oath or affirmation? I might begin with Mr Golding.
Craig Anthony Golding. I'm the President of the New South Wales Shooters Union. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you. And Mr Makem? Sounds like you can hear us okay.
Yes, I can. Thank you very much. William Edward Ned Makem. I'm the National Vice President of the Australian Pig Doggers and Hunters Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Look, I'm about to ask Mr Benasiak to lead off with the questions. We're going to try and ask questions collaboratively as an efficient way of helping you to give your evidence. And then at the conclusion, I'll give each of you a minute or so in case you feel that we've missed something or there's something important that you needed to add. So I'll begin by asking if you've got an opening statement.
Yes, I have.
Okay, please proceed.
Firstly, on behalf of Shooters Union New South Wales, I'd like to thank the committee for the invitation appearing today. Shooters Union New South Wales was extremely concerned with the proposals detailed in this bill and its veiled implications to the state's recreational hunters and recreational anglers. We believe this bill is less about overall animal welfare issues than it is about regulating and curtailing the growth of New South Wales recreational hunting and fishing. It's a grave concern to Shooters Union New South Wales that no hunting or fishing stakeholder groups were asked for initial consultation on this bill, despite contributing an estimated combined value in New South Wales of some $3.5 billion. While Shooters Union noted that specific exemptions have been made for legal activities such as recreational hunting and shooting and fishing, we don't believe these exemptions are specific enough to appease our members or the wider hunting and fishing community. The use of terms unreasonable and unnecessary remain far too subjective and, in our opinion, open to abusive interpretation by investigating officers, RSPCA, particularly considering their opposition to recreational hunting and their restrictive views on recreational fishing. The RSPCA has been an outspoken advocate for the abolition of recreational hunting and cannot be expected to give an objective opinion on issues where legal recreational hunting practices come into question. To that end, I've got the RSPCA information paper as they stand on recreational hunting that I'd like accepted into the committee, please. Thanks.
Thank you.
So is that RSPCA New South Wales or RSPCA?
RSPCA New South Wales, yes. Further concerns with this bill surround the fact that no mention has been made on the ongoing use of 1080 poison. 1080 poison is a slow killer. When ingested by an animal, suffers a prolonged and horrific death, with herbivores taking the longest time to die of up to 44 minutes, while carnivores can take up to 21 hours to die. How can we begin to discuss animal welfare with such diabolical control methods as 1080 being used as it is? And I ask, how soft and cuddly does an animal have to be, or a feral animal have to be, before it is afforded the same humane treatment as do our domestic animals? Australia and New Zealand remain the only two countries where 1080 poison remains in use, yet despite representations from various organisations, including Shooters Union New South Wales and the Game Management Council, there seems to be no appetite for this government or the Animal Justice Party to address the use of 1080 poison in Australia. Thank you.
I tried to ban it.
Sorry, can I
Thank
just...
you very much.
Just on...
No, Mr Makem. Do you have a statement?
Then you'll come back.
Yes, I do. It's just a brief one.
Thank you.
Also, I'd like to thank the committee for the opportunity to comment here, and I hope it heralds a greater involvement in the future in discussions on animal welfare and hunting in general terms. The Australian Pig Doggers and Hunters Association, for those who might not know, is the peak representative body for representing legal, ethical hunters of pigs nationwide. A lot of our members use dogs to locate and hold pigs. We were incorporated in 2005. We work with the department in New South Wales. We work with the Department of Primary Industries Game Unit in assisting with the administration of public land hunting. Our base view is that hunting in general, and particularly hunting using well-trained and well-managed dogs, is a legitimate cultural activity. It also provides significant environmental and agricultural and economic benefits to the community. So we have a number of ideas on how to progress this matter. We fully recognise the community has a legitimate interest in animal welfare. So do we. We think the two positions can be compatible, and what we're seeking to do is to find the common ground to go forward from this point. I say again, we see hunting with dogs as a legitimate cultural activity as well as a contributor to the economy pest control, etc. So thanks again for the opportunity.
Thank you for those comments. Mr. Banasiak.
Thank you.
Can I just refer back to this paper? Just because I did ask whether it was RSPCA New South Wales or Australia, and it was stated it was RSPCA New South Wales, but it's actually, by my reading, RSPCA Australia.
My apologies. If it pleases the council, the same policy applies to New South Wales, but I'll be happy to send that through at a later date if that's okay.
Thank you.
That's just an oversight. I apologise.
Yes, it's just an important distinction
Yep,
between the
100%
two.
agree. Yep.
Thank you both for attending, and good to see you both again. Mr. Golding, can I just come to one particular clause that hasn't been, that's in the existing legislation and it's still proposed to stay in the legislation. That's the issue of banning game parks. Do you believe it's a bit of a nonsense, given that farmers can actually charge fees for people to go onto their property and manage pests already, in a sense that you pay for, you know, a nightly camp fee and you get to cull animals for them, and that's done in a humane way? Is this persistence of banning game parks essentially a nonsense?
Yeah, look, I think it is. And for a couple of reasons. There's that reason as well where, you know, recreational hunters have for decades been able to spend time on a farm for a nominated fee to help control feral animals such as pigs and goats. That's ongoing. But then by the same token, how does that differ from a game park? And what is a game park? What's the definition of a game park? Game parks are quite common in Victoria and South Australia. And the reality is they differ little from a normal farming enterprise where you're raising sheep and goats or pigs or cattle for the human domestic market. So no, look, yes, we think there is a problem there with the definition of game parks. Yeah.
Can I go to your point about your concern in terms of you essentially being snubbed from the initial consultation, and you talked about obviously the huge financial
3.5 billion
contribution, that hunters make to the economy. I think it's, I guess, second or third in primary industries, I think, from memory. Is it also a concern, this snub, that the fact that this initial consultation, there was discussions being had and things being decided essentially on your behalf related to fishing and hunting?
That's correct.
Yeah.
Who has the right to determine who can fish and hunt without having consultation from those groups?
And not only where, but obviously how and the methods used.
Sure.
To go to this paper, appreciate there is a New South Wales version which is essentially the same. Does it concern you that obviously one of the principal charitable organisations that's doing the enforcement and potentially will do the enforcement has shown an active bias and continues to show an active bias against hunting? Do you believe that they can actually be trusted to be objective?
No.
Or even or do they even have the expertise to, under this new legislation, decide what is necessary or unnecessary in terms of hunting?
I don't think they can be trusted to be objective because their views on recreational hunting is to have it banned. But then how are they going to determine what's unreasonable or what's unethical? I heard the last lady mention about codes of conduct and codes of ethics. Modern conservation hunters and anglers are all bound by codes of ethics and codes of conduct. That is what makes up our licence applications. We need to agree to abide by these rules. How can they not be taken into account when we're looking at animal welfare?
Mr. Makem, do you have anything to add on that point?
Yes, the issue for us with the RSPCA, and I differentiate here between the administration of the RSPCA and the workers in the field. We've had good relations with the enforcement officers and people like that, so I'd like to make that distinction here. It does seem to me to be anomalous that the enforcement body, albeit separated on paper from the charitable body, it's anomalous to me and our organisation that they are then that they can hold a position that a legal activity should be banned, and that's an activity over which they have enforcement powers. If not an issue of bias, there's the danger of the perception of bias, and I think that has the tendency to undermine the credibility of the process. It's something that we'd certainly like to see taken into account.
Thank you. Mr. Dolan, just going back to you in terms of your submission, you talked about Part 2 interpretation, Division 2, points 7, 8 and 11, and this is about the unreasonable, unnecessary harm clauses that exist in, you acknowledge they exist in current POCTA rules. I do note that in the original discussion paper, there was defences applied for fishing and hunting, but then after numerous submissions raising concerns about the fact that it was only a defence, that was then changed to an exemption, but then still tied to this subjective nature of unnecessary harm. Do you see that it's that being tied to that unnecessary or what unreasonable as being the core issue?
I have an issue with what is unreasonable and what is unnecessary and who's determining that. But I also think the exemptions don't go far enough. They need to be specific. We're talking about legal activities here. We're talking about cultural activities, and these exemptions need to be specific to include legal pig hunting with dogs, legal boat hunting, legal rifle hunting, and legal catch and release fishing, which will in years to come will be an issue. So it just needs to be broadened. It needs to be more specific in what those exemptions are.
Yeah.
Could I jump in?
Yes, Ms. Abigail Boyd, please.
Thank you. Are we still in the morning? Yes, good morning to you both. I just wanted to pick up on the comments in relation to 1080 poison.
Yes.
It's great to see that you're in line with both the Greens policy and the AJP policy in banning 1080, and this is something that we are trying to work towards. And my colleague actually put a bill in quite recently. Are you of the view that 1080 should be banned because of animal welfare concerns, or because you worry that the use of 1080 will, I guess, remove one of the excuses for hunting?
No, I don't. I don't think the removal of 1080 is a quick fix, and I acknowledge that farmers, for instance, have a use for 1080. The problem, we're talking about the humane treatment of animals, yet here we are using a poison that's banned in every other country apart from Australia and New Zealand, and it can take up to 44 hours for a carnivore to die.
Yep.
How is that humane? Ms Hurst, I'm aware of your bill, and we've had correspondence on 1080 previously, and I have been critical because I think 1080 is brushed aside because of the tendency to go and pick the low-hanging fruit, you know what I mean, have a go at that. 1080 is a big issue. So to answer your question, I think there should be other methods other than 1080 employed more than what 1080 is.
With respect, if you're saying that you think that 1080 should be banned on animal welfare, for animal welfare reasons, but you literally hunt and kill animals for fun, how are we supposed to read that as being anything other than you seeing it as endangering?
Without sort of trying to get the philosophical argument of it, I mean, we're talking about a cultural pursuit that man has partaken in for almost, or over 2 million years. That's hunting, okay? A carnivore, such as a wild dog or a dingo, dying within 44 hours of ingesting 1080 poison is far different to me going out this weekend and harvesting a deer with one shot that's going to die within a split second, and that is the truth, okay? That deer to go home and become part of my family's food for the next 3 months. I get your point, and it can sort of sound to be hypocritical from a hunter saying that you want 1080 banned because we want to hunt more, but there's got to be other ways that can work in conjunction with hunting other than the use of 1080. We're not saying that hunting is a silver bullet, sorry the pun, but there needs to be other measures put in place that are far more humane than the use of 1080 poison.
Maybe we have an
Does that-
uneasy
does that
alliance
answer your
on that. Yes.
Yeah.
Did you want to jump in on that?
Actually, I think you've asked some good questions about 1080, and I think we do sit in a similar way, and I think there are other poisons as well, like pindone poison, which cause very prolonged suffering. In your submission, you argue that there should be an exemption for situations where a hunter has accidentally missed a clean shot and has been unable to kill the animal off quickly.
Yeah.
How often does that situation occur?
In my case, not very often. The thing we need to realise, let's talk rifle hunting. Those people that possess a firearms licence these days have to be members of a hunting club, and they've got to do a certain number of rifle range shoots each year. Okay, they've got to maintain their proficiency.
So if it's not very often that happens,
not
why
very
would we
often.
need an exemption?
So the exemption is to recognise that the legal pursuit of hunting is properly exempted, not just as a defence.
That sometimes it could cause prolonged suffering for an animal, and that should,
But
in and
it's
of
my
itself,
duty
be
as
an
the hunter,
exemption.
and we're bound by that code of conduct, that code of ethics, to ensure that doesn't happen. That's training, that's following
If
up.
it doesn't
and
happen, then why would we need an exemption? If we've got that in place to sort of say
Protect-
we're doing everything we
to
can,
protect the legal pursuit of hunting, yeah. That's why.
Can
And
I-
make it quite clear in the bill that the legal pursuit of hunting is completely exempted.
Can I just,
Okay, yes, Mr.
clarify
Kenneth, yeah.
on that point? Agree that it doesn't happen very often, but is it not, maybe the exemption might be the wrong word, but having a clause in there that says that, as long as you take the necessary steps that is listed in
Codes of conduct.
the Code of Conduct, and note for the committee's reference that there is a DPI Code of Conduct that all clubs have to abide by. As long as they adhere to that Code of Conduct that says you do everything practically possible to follow up and dispatch that animal, you are then not looped into this clause of unreasonable, unnecessary. Is that what you are trying to sort of get at?
doesn't that exemption in and of itself recognise that sometimes hunting causes prolonged pain and suffering to an animal? Just in and of itself? That there are occasions where that will occur?
I think that's been misrepresented.
How?
Can I just say, I do think, in terms of giving evidence, we've got...
It's gone off from the bill?
Witnesses' answers on that.
Okay,
I'm just worried that we're venturing into arguing.
into a different topic. I'll move on to it. Actually, I want to ask a question.
So can I just go back to the 1080 one?
Yeah.
While we're still near that. Taking it on face value that this objection to 1080 baiting is a purely animal welfare thing, what other stances has the sporting shooters taken for animal welfare?
Sporting shooters or shooters union?
Sorry, shooters union.
We work with, Shooters Union nationally works with farmers in all states to assist with whatever issues they might be faced with feral animals. But one of the big things we try to get going is that a lot more trapping is done. The use of, in particular with wild dogs, professional shooters, which it's more humane, especially with the
Their control methods, different
control methods, yeah.
So what other campaigns have you run supporting animal welfare objectives other than the
Not
1080?
Shooters Union, no. That's been done through the New South Wales Game Council.
Okay, thank you.
Okay.
I wanted to ask about, some groups have suggested that there should be an inbuilt statutory review of this legislation to review how the bill's actually going. I wanted to get your thoughts on this and what sort of time frame you think, if you agree that there should be a review once the legislation comes into place, how long you think that it should be when we review it?
You're probably asking something outside my expertise. I mean, 20 years?
Wow.
I don't know, Miss Hurst.
Okay.
5 years, 10 years. I still, what is wrong with the existing POCTA?
So much.
Where do you want to start?
It's quite old and it doesn't meet contemporary.
Could I?
Trust us.
Oh, sorry, did you
I just wanted to go to some specifically to Ned. I don't want to feel him left out there in digital land. Ned, can I just pick up on some of your submission there where you talked about the transportation of dogs? And I think you raise a good point around this, I guess, contradiction in the Act about the transportation of your pig dogs on the back of the ute and having them secured versus not having them secured when you're actively hunting. And you suggest that there's probably a case to include them in that subsection 3 there. So just so we're clear for the committee, you would be suggesting that that this clause of having them tied, you also be included in that subsection 3 exemption in terms of maybe saying use to control or protect stock animals and pest animals in the case of pig dogs. Is that what you're sort of suggesting?
The short answer is yes. Absolutely support the secure tethering of dogs for the obvious reasons of their protection and so on the back of a vehicle whilst moving at pace and so on. The variation occurs and on private land. It doesn't apply. So if people are hunting and the dogs are on the back of the vehicle, which saves wear and tear on the dogs, of course, what they're doing on the back of the vehicle is scenting and so on. So they have them loose so that they can react quickly to a scent. Now the variation, of course, would apply in our view to legal public land hunting in New South Wales in state forests. Now all roads in a state forest are classed as public roads. So the two sort of path bush track that's up the back of Nundle State Forest is classed the same as the Pacific Highway in terms of the requirement to have a dog, tethered. This restricts their ability to work, and there are workarounds for it. But what we'd like to see is that there is some sort of exemption for either certain classes of roads within a state forest that the dogs can work freely and move as they see fit. And that might be classes of roads, it might be speed, because we don't want to risk dogs being driven free on the back of a vehicle on the tray of a ute or something like that along, to take Nundle as an example, along Nundle Forest Way. It's a main road, it's a through road to the coast. But once off those roads and onto the bush tracks that go through the forestry, we'd like to see consideration for some sort of change there, as I said, either on classes of road or the speed at which the vehicles travel.
Yep. And can I just follow up on that?
Yeah, and then I think not
Sorry,
to take the chair's job, but Ms. Boyd's going to ask a
very
follow-up as
quick,
well.
very quick question. I just wanted to, in some ways that seems to make sense that if you're within a certain off-road area, but would you be proposing a speed limit on that? So
I think it's in his submission.
Yeah, yes, we're very happy with the speed limit. We don't know what that might be, but it might be, 10 k's an hour, 20 k's an hour. Someone with greater expertise than me on those sort of things would need to be involved. But the issue, of course, is that dogs either tumbling off a vehicle or even jumping deliberately and landing awkwardly, and you can get twisted fractures and things like that of legs. We don't want that. We love the dogs. And obviously that's why that law exists. The risk of that increases exponentially with speed. So a lower speed. Bear in mind that that's the actual speed that people are doing when they're looking for pigs, using a vehicle with dogs on the back. They're travelling slowly so that the dogs can react to scent and leave the vehicle.
Yeah, sorry, that was pretty much my question. The reduction of risk on those roads versus doing 110 along the highway. So.
Have you finished with that one? I just got to.
Yeah. I was just going to go to the stock welfare panel thing in his submission. But
I've got one before he's in the submission a bit earlier.
Yeah. Go, and then I'll jump back.
Mr. Makem, Mick Veach, in your submission, you talk about the licensing arrangements for hunting, and you're currently the only license required to hunt pigs with dogs applies to the use of dogs on public land declared for hunting, and there is no license for the use of dogs on private land. And your submission, you're advocating for the introduction of a license for all pig hunting with dogs in New South Wales, regardless of whether they're on private or public land. Is that correct?
Again, short answer, yes, and there are reasons for that.
Yeah, but then you go on to say that you believe, that you talk about the regulation, and you believe there's potential to significantly increase the focus on animal welfare and provide a clearer path to education and enforcement via the regulation. One of the issues we have is we actually don't have any draft regulations before us, and so you're proposing that would be something to be considered as a part of the regulation as opposed to the primary legislation. Would that be correct?
Yes, and again, slightly above my pay grade. I'm not a lawyer by any stretch. So
I'm just a busted up old shearer.
You keep saying that.
I don't know the correct structure, but I'd imagine that that in the regulations, and there's room in the draft information for these regulations, the reason we see that licence as of a potential benefit, because the regulations can have it as a requirement. It can have getting that licence governed by completing appropriate education on welfare, and that can be specific issues on, what constitutes good and bad animal welfare outcomes. It could be on the concept of social licence, but like what does the community expect that to look like? As a broad rule, we think education is the way forward for the animal welfare debate in our world. We think that education could be part of the regulations, and we think that licensing then would indicate that a person has undergone that relevant education and is a way of proving their capacity to undertake this cultural activity.
Thanks, Mr. Maker.
Can I just ask a clarifying question? It's just Emma Hurst from Animal Justice Party here. Can I just clarify, so pig dogging is currently happening on private land without licensing, or would this licensing actually expand where pig dogging could occur?
No, it's already happening on...
It's already happening, but there's no licensing scheme.
Correct.
Thank you.
Mr. Maker, can I just go to the comment in your submission about the stock welfare panels and how you'd like to see that expanded to include a hunted animal or game welfare panel? How would you see that working differently than the Game and Pest Advisory Board? And also noting that hunters were represented on the Animal Welfare Advisory Council only as an observer. And I think one of the criticisms hunters have of that process was there was a meeting before the meeting where everything was decided and the hunter representative walked in and had no say. So I'm just wondering how you would see that expansion.
Can I just clarify, are you referring to a meeting of this committee?
No, meeting of the Animal Welfare Advisory Council.
Oh, sorry, I've got you.
There's
a reference in this submission that I appreciate it.
Yeah, so how would you see that working? Would you want it separate to stock animals, or would you want it bundled up, or even if on notice, if you want to provide a bit of guidance?
I can provide more details on notice, but we see it as a separate entity and structured along the same lines as the stock welfare, animal welfare board. You'd want credible people who have an interest in from whatever side of the debate. But you need people who are actively involved in these things and looking for practical solutions. It's issue for us is, or one of the issues for us is that we are often ignored in this debate. We are spoken at rather than to. We hear people who don't like our lifestyle, and we are seldom asked for an opinion or to contribute. We have a good relationship with the DPI game unit, but we are looking to have people actively involved before we get to a confrontational situation. We think all these things can be resolved with education on all sides. Everyone has a different point of view on this, but we think that the more involvement you have, or that the process has with the hunting community, fewer issues there'll be.
Just picking up on that, and I noticed Ms. Boyd next to me angling for a question.
You're a question hog.
To both of you on that point, do you think having this game board in place would have maybe solved a lot of the problems in terms of your perception of poor consultation or not being considered in that initial phase? If this was already set up and you were being spoken, included in the conversation, do you think it would have potentially solved a lot of these issues that you're now talking about? Mr. Makin?
Yes, certainly.
Yes.
I think we need just a separate conduit to get our point of view in and to be taken seriously.
Ms. Boyd?
Thank you. I think in both of your submissions, although there are a couple of tweaks around things like the dogs in the back of in trays and things, the main concerns you appear to have are that this is kind of a thin edge of the wedge kind of legislation, and not that the legislation would currently change what it is that you currently do. Is that correct? And is there anything that you think this legislation would change on its face in relation to what you're currently allowed to do under the law?
Going back to my initial comment, I just think that when I first read the proposed welfare regulations, the first thing I thought of was this was a veiled attack on pig hunting with dogs. Okay, and to a lesser extent, bow hunting. Okay, and then I go back to when I read the Bradshaw report into rural crime back in 2016, which again had implications towards recreational pig hunting with dogs and bow hunting. And we seem to see a re-emergence of these things over time. It's unlikely that an investigating officer such as an RSPCA guy is going to pull up the shearer going from one block to another block on an open road. He's going to be targeting the young guy, long weekend, with police going out to Burke or Broken Hill. So yeah, I think it's a thin end of the wedge, and I think pig hunting gets a very, very bad rap. Pig hunting with dogs gets a very, very bad rap. So yeah, I just think it's a thin end of the wedge for further regulation on the sports, particularly of pig hunting with dogs and for bow hunting.
So perhaps before, Mr. McKean, before you answer the first question, I could add this one in for you specifically in relation to pig dogging. You've very helpfully included your code of conduct in relation to the management of not just the dogs but also the way in which the pigs are killed or hunted. You describe yourself as being the peak body representing ethical pig hunters. In your view, what would be an unethical pig hunter, and what is it that would fall outside of this code of conduct that you would discipline your members for?
Okay. I'm trying to remember what the first part of the question was.
Sorry, the first question was basically, will this change anything that you do in terms of the existing legislation? But then I was looking at what it is that you do and looking at the code of conduct.
Can I suggest that you just stick with the first question
and then we'll ask the second? Yes, I'm being greedy. I'm now being a question.
No, you're welcome to ask twice, but let's just ask them, separate them.
Thank you, Chair.
It will help you answer.
Please go ahead. So the first question.
Yes. Okay. Our difficulty with the suggested legislation is we think it's clumsy. We are looking for greater clarity so that we can provide better animal welfare outcomes. We have an ongoing debate with our members, and there are people outside our membership with whom we communicate as well. And so we talk to them about animal welfare and about social licence and these sort of things on an ongoing basis. The difficulty we have is that it remains, it hasn't got any worse, but it remains utterly subjective in our point of view. It can be a magistrate on a day or an officer on a day deciding that something's outside reasonable animal welfare.
So there's a fear that I guess your whole the whole practice of pig dogging would come under greater scrutiny if there was new laws. Is that your Is that your concern? And again, there's nothing in the actual legislation to change things.
No, not at all. What we're saying is that we are happy with scrutiny. Legal, ethical hunters are happy to be scrutinised, but they'd like to know what that scrutiny, the basis of that scrutiny. We'd like that clarified.
Yep.
So that's the basis of our submission. I wrote the submission. Sorry.
Thank you. So can we then come back to that second part of the question then, which is basically you are self-regulating under this code of conduct. What does an unethical big dog look like?
If I was to say what would be unethical activity, that would be not like we're in the business of killing the pig, so not killing them as quickly as is possible. You want death to occur as close to instantly as possible. Using more dogs than might be necessary for the dog's safety and for the pig. It might be the care and welfare of dogs, like, are they hot on the back of the vehicle? Do we need a cover for them? Do we need, we need insulating material on the floor of the ute, that sort of thing. How are they housed? The pointy end of this is what happens to the pig, and we make no bones about it. We are there to kill the pig. Pigs aren't released. It's illegal, and it's also it's problematic from an environmental point of view and a disease management point of view. So they're killed. So the whole focus of this, the primary focus of this, is how is that pig killed and how quickly it is done.
So my final question then is I understand that focus on the ethical hunting side and the idea that you're killing the pig quickly. But when I look at the code of conduct in relation to the requirements for how the dogs are treated, if this was the greyhound industry, for instance, and we're looking at dogs being, blooded and trained to smell out the pigs, when we look at the requirements here, the housing requirements, it's very much about not actively being cruel to the dogs, but there's nothing in here that provides for, a responsibility to provide a dog with a good life, and that wouldn't be accepted in the greyhound industry now. Are you worried that with the new legislation that sort of thing is going to be looked at?
Off the top of my head, I don't have any concern about that at all. It's inherent in our handling of the dogs that we believe we are giving them a good life. They get to live how it's described here by my non-pig hunting partner, is that the dogs live a big life. They share activities, they're mobile, they're fit, they're well cared for. Most of the stuff that we do with dogs replicates hunting. Throwing a ball, throwing a stick, teaching them to jump over things like this and that. We do those for their biological enrichment and their psychological enrichment. We take it as read that the object is to give the dogs, as good a life as possible. So, if that needs to be put in there just so that it's there, we could do that.
Yeah,
we're not.
I would recommend you update your code of conduct.
Okay.
Can I just on that as well? That also relates to those hunters that use pointing and retrieving dogs as well. I have a German Shorthair Pointer. It's nuts. It is part of the family. It has a good life. So how does it get determined that it's not having a good life? Under this current regulation, who determines that?
It's more about what you do when somebody who's not like yourself doesn't provide a good life for the dog.
Yeah.
Can I just clarify? You're asking about something that's not in the draft bill. Is that correct?
No, I'm talking about the impact of the draft bill, and we don't know what the regulations and the standards are going to be.
All right.
It will filter down.
Okay, so we'll just move on,
Very-
Mr. Deitch, and
thank
then
you.
I'll wrap it up. If that's
Very
all
quickly, my question's for Mr. Golding. Mr. Makeham's organisation, in their submission, talk about the specific reference in the draft bill to the structure of the stock welfare panels, and Mr. Bernasiak did touch on this as well. Mr. Makeham's organisation are supportive of the expansion of that concept to include hunted animal or game welfare panel. Is your organisation of the same view, and why?
I'd support that 100%, yeah.
And why?
Have a voice. Education, as Ned pointed out, is the key here. Shooters Union, New South Wales, my own hunting club, the Windsor Caribou Hunters and Anglers, spend a lot of time and a lot of effort on educating our members. That could be a simple thing of range practice days, right through to the proper butchering techniques of a game animal, so it's not wasted and left in a paddock to rot, which is a big thing because that's a lot of what the LLS work does. They leave stuff in the paddock and it rots and creates other issues down the line with
wild dogs,
foxes and honestly, Mr. Vitch, wild dogs are going to be the burden on this country or this state in the next decades. They are a horrendous problem.
If they're not already.
Look, they are now, but they are going to be worse. And what we find, I'm digressing, I'm sorry, Madam Chair, but we're seeing a crossbreed happening, and the practice of aerial culling, which we haven't 1080 poison, you're leaving carcasses in the bush that provides ideal breeding grounds for these things. And when those carcasses disappear from the bush, where do they go? Where do the animals go? Where do the wild dogs go? Straight to the farms and predate on the calves and the sheep and the cattle. So something we need to address that aspect at some point as well. We can't continue to be shooting stuff from the air and not take the responsibility of that, the downside of that responsibility. Okay, sorry, I got off the point. Sorry.
Are you okay with that?
Can I stay on the stock welfare panels for a second? Unless I've missed
1 minute left.
Yeah.
So.
My understanding of the stock welfare panels are they're an early intervention for someone managing stock to prevent that from getting to an animal welfare issue. I imagine the animal welfare issues happening around hunting are fairly instant. I'm just not sure whether the stock welfare panel is. I understand. I think what you're wanting, but I don't think it's similar to a stock welfare panel, unless I misinterpret what the stock welfare panel does.
Maybe I don't want to drive the witnesses too much, but maybe it's not necessarily about that instant or that intervention early. It's more about a place to be heard and
I would like to see more about what I know Mr. Makem suggested he could provide more on what that might look like.
Maybe we'll leave it at that.
On notice.
On notice.
Yeah.
Oh, okay. Thank you. I'd just like each of you gentlemen to have an opportunity if you felt there was something you'd like to say before the conclusion. Mr. Gold.
I think I'm fine. I think I've covered everything I wanted to. Thank you very much.
Thank you. And Mr. Makem.
One thing that I failed to do, and pardon me for my lack of understanding how things operate. This is my first parliamentary committee. I wanted to also table a document. I have it here. You should also have copies of it from the New South Wales Animal Welfare Reform discussion paper. There's just more information in it. There's some other, supportive information, that might be useful in your consideration. On the stock welfare panel concept, hunting, welfare panel, what we see as an idea there is that rather than, while there might be a particular practice, that could cause issues, we see it as an ongoing education sort of tool that can also be used to say, when we are doing this, these are the problems that might arise, these are the ways that you can counter them. And that can include in the way dogs are handled, or trained, et cetera, et cetera.
Yep.
But anyway, I am happy on notice to provide
Thank you.
a draft on what that might look like.
Thank you. And please be assured that we're all sitting here now with that paper in front of us. So thank you for making that available to us. Okay. So yes, thank both of you gentlemen for coming and giving your evidence today. Any questions that you've taken on notice, the Secretariat staff will follow up with you. And we will now break for lunch until 1:15. Thank you very much.
Thank you.
Thanks for asking.
I have taken that to heart. It's very important.
Lights in action. Well, thank you, everyone. I now warmly welcome our next witnesses to this inquiry. It is Mr. James Jackson, President of New South Wales Farmers, Ms. Annabelle Johnson, who's the Head of Policy at New South Wales Farmers, and Ms. Margot Andre.
Andre, yep.
Correct me if I'm, who's Chief Executive Officer of the Australian Pork Limited. Thank you all so much for being available for this hearing. Could each witness please state their name and position and title and swear either an oath or an affirmation? And I might start with Ms. Andy and then we'll...
Ms. Andre?
Andre. Thank you. Thank you.
Thank you. So Margot Andre, Chief Executive Officer for Australian Pork Limited, and I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you. Mr. Jackson?
James Jackson, I'm President of the New South Wales Farmers Association. I solemnly...
It's a hard word, isn't it? Everybody. It's a little warm-up.
Right, it's going on the bloopers reel, Mr. Jackson.
Solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you. Nice to see you again. Ms. Johnson.
Annabelle Johnson, Head of Policy and Advocacy at New South Wales Farmers. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
That's how you do it, James.
Thank you. Now, in a moment I'll ask both organisations if they'd like to make a short opening statement. The way that we've been doing questions is a member has been asking a question and we're all just working together as a team to sort of chip in other questions around that topic. So we feel that's going to be easier for the witnesses, not to be running. And then right at the end, I will make sure that a little bit of time is allowed if you have anything that you feel that we've missed or that needed to be said for you to have that opportunity. Okay. So, New South Wales Farmers would...
Thank you very much. Good afternoon. My name is James Jackson. I'm President of the New South Wales Farmers. New South Wales Farmers is Australia's largest state farming organisation, representing the interests of its farmers' members. We're Australia's only state-based farmer organisation that represents farmers across all agricultural commodities. Agriculture is the heartbeat of regional communities and serves as the economic engine, if you like, for New South Wales, producing $17 billion worth of produce every year. Our grassroots structure means that our members are the final arbiters of policy, and indeed we have a robust democracy that demands our members essentially are the ultimate arbiters. We represent sheep, wool, cattle, goats, dairy, pigs and poultry, amongst others. We believe that it's critically important that farmers are provided the opportunity to engage and provide comment on this important bill. The health and care of animals is critical for farmers. As the primary caregivers to animals in their production system, farmers play a central role in protecting and improving animal welfare outcomes. This is our core business. We actually invest voluntarily levies up to about $100 million in research into health issues. We are economically married to good welfare outcomes. You are speaking to the preeminent welfare advocacy group in New South Wales. New South Wales Farmers believes there's a foundational issue with the approach to definitions within the draft bill. Our members support the inclusion of a definition of animal welfare within the draft bill. Absolutely critical that we actually have a definition. You can't regulate something that you don't define. And it's absolutely critical that this bill actually investigates and interrogates a definition of animal welfare to make sure that we know what it does mean and to know what it doesn't mean. New South Wales farmers support that concept and a definition based on a holistic view of health, backed by science, a science-based approach. There is a huge amount of emerging science around measuring animal welfare outcomes and measuring how an animal is responding. The definition must be based around animals. It must not be based around an anthropomorphic sort of interpretation of what that animal should feel like, because we do know how animals respond. We also hold concerns over the scope of the regulation-making powers within the bill. New South Wales Farmers believes that all acts of cruelty and animal welfare offences should be specified in the bill, with no additional regulatory powers to prescribe additional acts of animal welfare offences in the regulation. So it must be in the bill. And this is one of the critical areas of this bill that we are very critical of. Further, we raised concerns with the uncertainty and lack of clarity throughout this draft bill. New South Wales Farmers and its members welcome the opportunity to comment on this inquiry and look forward to your questions. It is an important issue.
Thank you. Australian Pork Limited.
Excellent, thank you. So thank you for the opportunity to be here today on behalf of over 4,000 Australian pork producers and our sector's 36,000 employees and their families deriving their livelihoods from our $5.3 billion industry. APL is unique in terms of livestock industry representation. We are a producer-owned organisation. We promote sustainable growth across the Australian pork industry's entire supply chain by overseeing integrated marketing, research and innovation, and policy initiatives for the whole industry. Our progressive model means we sit at both the R&D and representation tables and can truly be one voice for industry. As a leader in animal care, the Australian pork industry is committed to continuous improvement in pig welfare. Our industry strongly believes that robust scientific approach to welfare is the basis for a sustainable industry in terms of community expectations, commercial realities, and ensuring the best outcomes for the pigs within our care. Our industry invests significant funds each year to research new technologies and practices to improve pig welfare and provide valuable education and training to stop people throughout Australia. This research aims to inform industry practices and the standards and regulations that underpin them. APL supports the review of the current Prevention of Cruelty to Animals Act 1979 and drafting of the Animal Welfare Bill 2022 to ensure New South Wales legislation reflects the latest science and community expectations. However, firmly believes that this review must not create unintended negative animal welfare impacts or unnecessary regulatory burden for all animal-based industries. Currently, the national minimum science-based animal welfare requirements for pigs are defined in the Model Code of Practice for the animal welfare, for the welfare of animals in pigs, or the Model Code. Our industry proudly ensures adherence to the Model Code through the pig industry's voluntary quality assurance program, APIC, which also supports many of our producers exceeding minimum standards on a daily basis. The Model Code has been slated for a refresh and replacement by the Australian Animal Welfare Standards and Guidelines for Pigs, or the PIGS S&G. APL is encouraged that New South Wales Department of Primary Industries and New South Wales Government also recognises the importance of nationally consistent, regulated minimum standards that are recognised within all jurisdictions' welfare legislation. Given the importance of the standards and guidelines, it is imperative that the process used to develop current and future standards and guidelines is reviewed and refined. This sorely needed review should not only ensure that the multiple frameworks currently in use are aligned into a single approach that provides a fair, equitable and consistent process for setting welfare standards, but also garner the trust of industry, government and community alike. Legislated welfare standards and guidelines must also be supported by compliance and enforcement functions which are adequately resourced and delivered by appropriately skilled personnel with an understanding of the industry. And I'm pleased to answer any questions that anyone might have. Thank you.
Thank you very much. I thought I might ask my colleague, the Honourable Mick Beach, to lead the questioning. And Scott, are you wanting to go in after?
Yep. Thanks, Chair, and thank you for your submissions and your attendance this afternoon. Mr. Jackson, your opening statement, you're pretty scathing around, pretty adamant around the regulatory making capacity contained within the bill, essentially saying that there's a lot of things that should be in the bill and not in regulations. And I've posed this question to a number of panels today, so I'm not the first to hear this, but do you think it would be better for the draft regulations to be presented at the same time as the draft bill for consideration of the legislators? That allay your fears around the regulatory making capacity of the bill?
No, actually, it wouldn't, because it's absolutely critical that the Parliament, it's sort of a vote of confidence actually in the parliamentary process. It's a vote of confidence that any new construct, if you like, actually has the oversight of both houses of this Parliament, and is not something that can be imposed on industry, through a regulatory instrument. I think that's the principal reason that it's got to be actually included in the bill, and I would encourage you to look at that, because I think having a range of regulatory or regulation in fact potentially compromises investment and confidence in the industry. That's something that could be imposed on industry that completely and utterly makes huge investments redundant, with a swipe of a pen of a regulator. I'm very concerned about that. I mean, we've seen that in the poultry industry, where there's $2 or $3 billion worth of stranded assets, if you like, that haven't seen the end of their life, and I think there's risk. There's risk in investment in agriculture. There's risk for the animals, and I don't think that's a good idea.
Okay, thank you, Miss Andre.
Look, probably just to confirm what James is saying, but I think the bottom line is that when you're putting all these regulations and the legislation in place, you have to really understand the consequences of it and what it means for the farmers, what it means for the economies, what we're trying to do, and what it's actually going to change, and make sure it doesn't have those negative impacts. So it's got to be really well thought through. It's got to be engagement with industries. And I think, dare I say it, I'll speak on behalf of other industries as well, it feels like they're being smashed with red tape. A lot of red tape, and I think it's about making sure that any changes really are for the benefit of the outcome that you're desiring. It's about, we already practice those minimum standards. We're already putting animals at the highest level of care, and we are very, very privileged to provide high quality protein in this country and to feed Australians. And we do that as a privilege, and I mean that quite wholeheartedly. We are privileged to provide safe protein, and a lot of countries don't have that luxury. And I've travelled overseas and I've seen where parents can't feed their kids that protein because they don't know if it's safe. They don't know if it's going to make their kids sick. We are so lucky here in Australia. We have the highest level of animal welfare, we have the highest biosecurity, and we are incredibly privileged, and we do our best for those animals because those animals doing well actually does give us the ability to do good business and to feed Australians. And I think that's what I come back to, is you really need to be careful of the unintended consequences of what you're driving. We have already lost so many manufacturing and industries in Australia, and COVID has taught us that. If we want to lose our ability to supply fresh food to Australians, over-regulation, over-legislation is going to do that. I come back to, as long as we are working with the people who are impacted by these changes and making sure that they are fit for purpose for the intention that they're being used.
Is this on this topic, or have I got another one?
Yeah, no, it's
Okay.
coming off.
Can I
of
follow
that,
up on this
but
topic as well?
You go first.
Just coming back to the regulations, and I apologize for missing your presentation, Mr. Jackson, but if we put more of these, what are slated to be regulations, into the bill, does that not risk them in getting caught up for another 40 years before we can shift them again? Like, this has not been an easy and will not be an easy process, but having them in the regulations would, I guess, make us more agile to adjust with industry standards, new technologies, new developments?
The problem is, as I described before, the problem is, I mean, if you react, and this is a fraught area of regulation, if you like, where we've seen, essentially a Four Corners, episode on live export, a get-up poll, and then we've seen the industry close down overnight, based on noise, based on things that essentially were not evidence-based. We sorted it out. We did get through that process, but the potential for reactive type of responses to, the sky is falling, animal welfare, or largely it's animal rights, issues, is significant. So that's why we're very, very circumspect about having too much of this embedded in regulation, which can be done at a stroke of a pen, and we don't actually have those rigours, if you like, of something that's included in a bill. We don't have the rigours, the cost-benefit analysis. We don't have the regulatory impact statement. We essentially circumvent, proper scrutiny. So I'd argue, be careful. Be extremely careful.
Ms. Boyd.
Good afternoon. I wanted to just pick up on I guess we heard earlier from an earlier panel that New South Wales's animal welfare laws are perhaps, should we say, not as animal friendly as some of the other animal welfare laws across Australia or internationally. I just wanted to ask you, if we're looking at something, they put forward New Zealand, for example, as being a jurisdiction that has pretty good animal welfare legislation in from their perspective. Clearly that was introduced. They have a concept of animal sentience in there. People aren't going without food. What's your impression of what those impacts have been on the New Zealand farmers, and why are we concerned in New South Wales to tighten the regulations here?
I don't actually accept the premise of your question that we're sort of somehow should be taking a lead off New Zealand animal welfare.
It's not what I said, though. I was talking about from the if we were to look at farmer friendly versus animal welfare friendly, you were talking about, and I can see that you would not see that as being in conflict, but you talked before about being concerned about this sort of an overreaction or somehow animal rights ideas getting into the legislation. If we were to plot all of the different sort of animal welfare regulations from different jurisdictions on a line, you would get those that I suspect you would find more along the animal rights line of thinking, as opposed to those that aren't. The people that we spoke to before were telling us that in their view, the more animal welfare or animal friendly jurisdictions are those such as New Zealand. I'm saying to you, if New Zealand can have that sort of legislation and still have a thriving farming industry, what are we concerned about in New South Wales?
Don't undersell what you've got in New South Wales. You've got some really sensational animal welfare laws in New South Wales. I'm looking at essentially the regulation of foot rot in sheep in New South Wales. They don't have that in any other state in Australia. They don't have the same level of essentially intervention in foot rot management. Foot rot is a disease where the sheep's feet fall off with virulent foot rot. They are in distress for a number of months. It is a terrible animal welfare impost. New South Wales has a plan. New South Wales in 1990 had 12 million sheep with virulent foot rot. Now we've got something like 500,000 sheep with virulent foot rot. So don't underestimate what you've got and the outcomes that you're getting in New South Wales. Some of them are absolutely top drawer. People come from all around the planet to look at how we manage foot rot in sheep.
With respect, that was it's not my question. My question was not how do you view the current New South Wales welfare standards. I was saying to you that if this is an inquiry about a specific bill that has been put forward. I heard from you in your opening statement and in your comments, you were concerned about a drift towards embedding sort of more animal rights, I don't know, a word vibe into these laws. Given that there is far more progressive legislation in other jurisdictions and their farming industries are still thriving, why are you so concerned about our legislation being updated to more accurately reflect community standards?
Well, I think I articulated that before. I'm concerned about an industry being closed down overnight, with a stitch-up. The Four Corners stitch-up on live export was a classic. It was a classic. So
Did that happen in New Zealand?
Sorry, let's just finish this.
Yeah.
Thank you.
So the potential problem with conflating animal rights with animal welfare is not, it's not useful for the animals. It's not, and I'm arguing that it's not useful for the animals. That is why you have to have a definition. So, I mean, you know, have a look at the definition. Have a look at the OIE definition. The OIE is the UN body that looks after, you know, has international carriage of animal welfare definitions. New South Wales Farmers' definition for animal welfare is based on the OIE one. It's slightly different. We've nuanced it slightly differently. It makes sure that it's agnostic to animal rights, that it's actually focused on welfare. It's actually quite critical to understand what welfare is.
Would I'm going to ask one more time just to try and see if I can get what I'm looking for here, which is you as an association, you must have contacts with people, your equivalent in other jurisdictions.
Yeah.
When their legislation was updated to a level that is still far above in terms of animal rights or progressive animal welfare legislation than what is being proposed in this bill, did their industry suffer? Is it still a thriving industry over there? Is it the case perhaps that you're a bit worried about something that's not going to eventuate?
Can you give an example, maybe a state?
Can I make a comment here? I think the concern is with pushing too much into regulation and what is required of farmers. If that can be changed, or of anyone that has to care for animals, changing that too quickly without due process. So if that can be made quickly, that isn't beneficial for any animal owner. It doesn't endure to trust in what they need to occur. So as this is about regulatory and setting the minimum standards, we need clarity for anyone that is needing to care for an animal. They need clarity about what is going to be required. So we have concerns that moving the regulatory power around, especially definitions of animal acts of cruelty and animal welfare offences, we think that they can be clearly defined in the Act and should not be within the regulatory making framework. Just because they're in the Act doesn't mean they can't be changed. We think that going through both houses of Parliament ensures that any new science that might come forward will have a chance to go through both houses and have due consideration by our elected members with due input through the community. So I think that's where our concern is. It's around the lack of clarity about what is going to be required and concern that too much could change too quickly. Both ways. I think it's a concern with the community across the board that if you're not going to have clarity about what is required, then it's difficult to build trust.
Can I ask you on that, what are the things that you think are going to change under if this draft bill were to proceed? What would change?
Well, I think it's very difficult to say, but some of our key husbandry practices that aren't viewed in the whole of the animal's lifetime, and this is where we come back to our definition of welfare, that we need to view these husbandry practices that are undertaken in the lifetime of the animal, not as a point in time. So,
sorry, can I just clarify? Are you fearful that could emerge as an outcome, or do you see that actually in the bill now? Well, are there practices in the bill now are there provisions in the bill that will change these practices?
So we're not concerned about the restricted and prohibited practices that are currently in the bill. I note that there were concerns raised by other stakeholders about some of those definitions, some of those practices. They're not a concern for us.
But a number of witnesses today appear to be anxious about what's driving this bill and feeling like the bill may be motivated to get them, if I can put it like that. That's a blunt way of
That's a good way of putting it.
I think the shooters and the pig hunting people, and I'm just kind of getting this impression as well. But I suppose as a committee reviewing the bill and accepting that anxiety and concern, and I'm just wondering if there is anything actually in the bill that, or is it what you think might happen because of the bill?
I think it's a lack of clarity that's provided in the bill. I think the best analogy I can give is it's a skeleton that we're looking at the moment, or a frame of a house, whereas we all want to see the whole house to understand what might be required of us. We haven't got that at the moment. I draw attention to sort of the minimum care requirements. It makes a statement around appropriate, or we'd like to know what that means. That's not clear for people at the moment. It's different terminology from POCTA. So does that mean that what the courts have decided previously, does that transfer across? There's a whole lot, and I think coming back to Mr. Veach's point about the regulations not being there, not seeing it's essentially going back to my house analogy. We're only seeing the kitchen and the bathroom. We're going, well, where are the bedrooms? Where is it all, and how does it all fit together? So that's part of where I think that some of the concerns are coming from.
Do you think that the actual endeavour of consolidating the legislation into this, do you think it is actually a worthy thing to do? I mean, I was quite interested that the pork industry seemed to be saying the process is fine, and then unpacking that into what the concerns were. But in principle, how do you feel about that?
In principle,
just having a new bill that seeks to consolidate.
We've always sort of seen the modernisation of POCTA as an important step, as I think everyone engaged in the process has. We've obviously been coming at it just from a production animal perspective, slip of the tongue, production animal perspective. So I was interested to read some of the other submissions, raising concerns about, well, how premises is defined, how a few of these definitions are defined. And I think we're only starting to see those now as we're seeing a holistic bill. So if I come back to your question, as a principle, we can see the benefit in modernising and trying to streamline. And this is where, we can provide our input into making sure it's going to work for the production sector, and that's where issues that aren't issues for us are becoming issues for the research and the exhibited animals and the companion animal sectors.
I think Scott had.
Ma'am?
Yes, thank you.
Yes, sorry.
May I just add to Miss Boyd's question though? Miss Boyd, you specifically asked around New Zealand production. New Zealand is much smaller, but their production is growing smaller. They are getting more and more reliant on importation, particularly around pigs. And here in Australia, it might surprise you to know that 80% of your small goods for porks is already imported. So I think if answering just your specific question,
that does answer.
It has potential to have an impact on the industries. And again, I probably come back to that point. Do we want a homegrown Australian food security solution? And in New Zealand, they are losing that.
Okay, thank you. That's the kind of evidence I was after.
Do you mind if I just want to ask one more question, and then the EU, in terms of international trade, partners like the EU are increasingly mandating this and mandating that in terms of standards, animal welfare standards around production. And I just wondered if you had any comments about how Australia should be responding to that. And also, I note that that will be affecting every single farmer in the country, not just in New South Wales. And do we have a good system in place to ensure that our industry is assisted while those changes are coming in? Thank you.
I can have a crack at this one. It is interesting. I mean, the WTA, the GATT arrangements, that dictate how a third party or a trading partner can actually impact or ask for certain conditions with respect to product going into their country. They can demand that product going into their country, has a certain provenance. I mean, there's all sorts of irrational, non-scientific things that the Europeans ask for, like, glyphosate use, like HGPs, all sorts of things that really are not based on science. They're based on, consumer preference. Consumers are always right. So, we are an exporting country. We put product into supply chains that satisfy those demands. The principal thing is that we've got a system, and certainly in the red meat industry, we've got a system that has a bespoke supply chain for supplying European product. Now, it's demanding certain things for that product going into the country. It's basically around HGPs, but it could actually, with the EU free trade agreement, it could actually have other demands, if you like, on getting access into the EU market. But we have actually bespoke supply chains that supply product that comply with that particular demand. Essentially saying that because the EU have demanded this, that that you should defer regulatory powers to Brussels is inappropriate. It's inappropriate because we've got regulations in this country and we've got production systems in this country that's actually superior to the European systems, I have to say. The idea that Europe is some sort of exemplar of animal welfare outcomes is to be seriously challenged, and I certainly can give you case studies after case studies where they're rubbish at doing animal welfare. So it is important to defer to the marketplace, and it's important to understand that we've got processes that supply product specifically for those markets, and we can do that.
So there's an accreditation process, as I understand it.
There is.
There's an the federal government has a body of some sort that's...
ISO 1009 accreditation program that's independently audited to ensure that HGPs don't enter that supply chain. So we've essentially we comply with those things.
That's not a legislated standard. So there are actually other compliance regimes in place.
Yeah, it's
nothing to do with legislation that are governing how animals are being managed on farms.
Well, that's right. That's right. I mean, various people have various views on what's good animal welfare outcomes. And, in the wool industry, for instance, there's a lot of people around the planet who have reservations about mulesing, for instance, which is an operation that stops animals, helps to prevent animals getting horrific fly strike, for instance. You guys had an inquiry into
we know
mulesing.
Mulesing,
I think you would know all about mulesing, which is it's terrific actually that education process occurred. Now there is a lot of our markets that have reservations about mulesing. We actually sign a statutory declaration, even if we mule, and I do mules. I signed a statutory declaration, and so the people buying my wool understand that I mules, and if they don't want to buy that wool, they don't bid on it. That is a bespoke sort of arrangement that is independently audited to make sure I tell the truth, that I don't mule, that I do mules. I don't know why I'd lie about that, but and essentially that is a transparent proposition, if you like, through the marketplace that actually, engenders confidence in our markets and ensures that we're keeping that compact with our consumers. We are very aware that animal welfare, issues, resonate with a lot of our marketplaces. We can do this by actually just telling the truth on some of these declarations, and we do it very well in Australia. Best practice. Other people are looking at how we're doing that.
May I ask a follow-up question just to that? I just... Thank you. So you don't have any concerns that, obviously there's organisations, there's animal welfare organisations for example, in the UK that are campaigning to their parliament to actually block all farming imports from Australia. Is the New South Wales Farmers Federation, is Australian Pork Limited worried about those campaigns and worried about the fact that if we stay where we are or if we don't make some changes that are sort of more globally accepted, that could potentially block Australia out of the world?
Essentially, the non-tariff trade barriers are certainly a significant issue for us, and we spend a lot of time defending that in WTO. We've got industry structures that do that, so we are aware of people trying to use, things like multing or. It is interesting that whether we should complain about importing product from Europe that is housed for 6 months of the year. If you're talking about welfare outcomes, a lot of their extensive, output, for sheep and beef and sheep are housed for a certain number of the year. We think you can do that properly. A lot of people have concerns about housing.
And if Australia sort of
Intensification of industries has been demonised. It's actually very good. I don't have a problem with Europeans doing it, but the problem is there is a number of people who have got concerns about it.
And I'm sure, in Australia, there can be decisions made in regards to the importation based on certain standards. But I'm more asking if you as sort of peak organisations have concerns about those campaigns that are being run overseas and what long-term impacts they'll have if we just continue to stand still in our legislation.
Well, we're not standing still.
Can I ask Ms.
in
Andrew
our
if you'd like to add to that answer?
I would. No, you're fine, James. So I guess from the pork industry, we take what's happening globally very seriously. Many of you would know we voluntarily phased out sow stalls. And we continue to watch what's happening, but we continue to monitor our own community expectations back here in Australia. But dare I say it, we are 90% focused on Australia in our production and only 10% export. We do have to meet incredibly high standards to export our pork, but we have to meet incredibly high standards to function here in Australia. And I think as much as we talk about animal welfare, we have to be also talking about biosecurity. We have to be talking about looking after our workforce. We have to be talking about sustainability, looking after the planet. And we are people, pigs, planet, prosperity. You can't have one without the other. It's about making sure we're looking after all of them. So I think in answer to your question, I'm actually going to slightly put it back and say it's really time for Australia to celebrate the amazing things we do here around our animal welfare and meeting those minimum standards. Our APIC certification system is voluntary and covers almost 90% of our industry in production. And that's voluntary. People pay for those audits, and when we start to introduce things that are confusing, it is really hard to audit those things if there is no quantifiable measure for them. So I come back to the basics of a really strong measure that you can actually hold people to account for. And in terms of what's happening overseas, those countries don't, and I know this from the beef industry, I know it from the pork industry, they do not have to meet the same standards we meet in terms of looking after people, looking after the planet, looking after their animals. And it's, we really need to celebrate that Australia is disease-free. You have a look overseas and there is disease rife through a lot of the other industries overseas. So it's not just one element here. We really should celebrate that we do amazing things across all areas and they are all interconnected. You can't do one without the other. So I'm a little bit with James, our cattle industry is held to very high standards, but yet in it's parts of Europe and the US, they go and celebrate and have a party to let cattle out of a shed after being locked in there for 9 months. Whereas our cattle roam free, well looked after, and we're meeting all of these standards, whether it is HGP, whatever it is, we're meeting those standards. But individual producers choose those markets to go to. They choose to meet those standards. And I think in supporting those industries and supporting the food security that they're providing, it's about actually supporting them to do business, because we won't have food security if we don't start supporting them, because people are going to actually get confused and be unable to meet those guidelines and be being penalised for doing the right things by their animals because of the confusion that some of these terms and definitions may create. Thank you, Chair.
Mr. Panasiak.
Thank you. I think we've sort of covered the philosophical arguments back and forth enough. Can we go to some specifics? And I'll turn to the submission from you, Ms. Andre, about the powers of authorised officers entering non-residential premises and the concerns around biosecurity. I think it's very topical at the moment with Japanese encephalitis, but the pig industry does cop this a lot, the swine
fever.
Flu, swine fever. Would your concerns be alleviated if there was some sort of link back to the Biosecurity Act that made sure and made clear that those authorised officers had to abide by those security measures, and there would be then consequences if they didn't. So then they would actually also be tied into the enforcement of this Act, that if they breach it by essentially breaching the Biosecurity Act, they are also liable for animal cruelty offences. Would that create some sort of...
We would celebrate if these legislations and regulations were stopped being being developed in isolation of everything else that producers need to adhere to. Because you're right, African swine fever will wipe out our industry. We've currently got JEV, which is an early alert system. The only reason the health department knew it was here was because of our pigs. So I think, to answer your question, yes, we would support a holistic approach to implementing changes to legislation and regulation.
Mr. Jackson, I think you wanted to sort of add something there.
Absolutely. The nexus between biosecurity and animal welfare is inescapable. It's inescapable. I mean, the work actually, and the work that came from this Parliament to drive, that onshore biosecurity levy, to make sure that we actually look at what's in containers. The impact of what is in a container, that is not cleaned out properly, the impact on animal welfare is potentially catastrophic. It's potentially catastrophic, and making sure that we get that alignment between federal, state and local authorities on biosecurity is an absolutely critical piece of work. So yes, biosecurity, animal welfare, they're related. Biosecurity, animal production, economic prosperity, they are related. So these things, animal welfare is not to be considered in isolation. And the idea of having, an independent office of animal welfare away from the DPI is crazy. It's crazy because, what that does is actually remove, animal welfare from all the levers that can actually drive animal welfare outcomes. It's bog crazy, and you shouldn't even consider it actually, that animal welfare is some sort of separate construct. It's related to all these other activities that we do. And we as farmers, we understand this. We understand that, if we get foot rot or OJD onto our place, it has a significant impact on those animals. It has a significant impact on our bottom line, and that's why we spend a lot of time and money preventing it.
Chair,
Sorry,
it's not a question. I just wanted to get some something on notice. But Ms. Andre, before you said, very helpfully, the evidence you provided in relation to New Zealand, I couldn't find any evidence of that in the national statistics.
Okay,
if you could, on notice, please provide me with that information. That would be excellent. Thank you.
Okay, thank you. I'm sorry.
Thanks, Chair. Sorry, I would have liked to hear more about the pork industry and some of the stuff they have done, but unfortunately we're out of time on this one. I do need to clarify.
We'll allow you some time.
I guess more importantly, I'd like to clarify something from the earlier sessions where a couple of groups have pushed for a banning of 1080. Mr. Jackson, can you just quickly, outline some of the implications of an immediate ban of 1080 poison?
Completely ill-advised to ban 1080. 1080, if to the casual observer and to the untrained observer, the death does look confronting because essentially 1080 knocks out fluoroacetate, knocks out glycogen metabolism, and so it knocks out the top of the brain first, and you still get base responses. You get from the cerebellum, and essentially you can get some paddling and some whining. It looks to the untrained eye, it looks like it's the animal's in pain. It is not. There's 2 peer-reviewed papers on this. I've actually lobbied this Parliament previously on this issue. There's a total of 2 peer-reviewed papers. It is, of course, very difficult to actually understand the humaneness, if you like, of the death with 1080, but it's absolutely a critical piece of kit that we've got for controlling all sorts of things. Interestingly, 1080 is a natural product in Australia, and animals like quolls actually have an inherent resistance to it, where non-native animals like dogs and cats do not have that resistance to it. So it's actually quite a good selective poison. So the rate that we use in dog baits, for instance, do not kill quolls, because their metabolism have actually evolved to essentially be resistant to that sort of dose rate. It is interesting, in New Zealand, they're the biggest users of fluoracetate on the planet, and they've got to use it to control possums, which are an Australian native that's gone feral in New Zealand, and they have to use really high rates in New Zealand to control those possums. So they've got a bit of a problem, with the possums there. I would urge you caution on banning 1080. It's a very valuable tool. There are problems with it. There's no essentially you can only use an emetic, if you like, something to cause them to throw up the bait. There's no sort of systemic antidote for it like there is for sodium nitrite. But on the other hand, it is actually highly specific. So the LD50, the toxic dose rate is such that you can actually put the amount in a bait, and they do this at the LLS. Your guys at the LLS do it really well. They put it in the bait, and it's sublethal for humans, except maybe very young people. For humans and dogs, so I would be very careful. We've got mechanisms in this country to manage 1080.
And just quickly,
don't throw it out.
Your qualifications to talk about it at that level?
Yeah. Look, I'm a veterinary surgeon. I am across this one.
Okay, thank you. Can I just ask both of you? I will allow an opportunity, but only to say if you could be brief. Thank you.
I'll be really brief, but can I just add to the 1080? We manage the feral pig program here in Australia, so we actually run the federal program, and feral pigs in this country do over $100 million a year in damage to farms, to environmental assets, to cultural assets, and at the moment 1080 is one of the best ways of baiting and dealing with those feral pigs. So whilst we continue to trial and find new things, which we will continue to do, 1080 is one of the best things that we have available to farmers, and feral pigs are a nuisance.
Thank you.
I just wanted to draw that link in with the environment, because it is very important. It not only impacts on agricultural production, but ineffective animal management has a highly detrimental impact on our environmental resources as well.
Thank you for that. I might do a wrap up. Okay, thank you. Can I just ask each of you, is there anything that you feel that we missed or that you need to correct or say?
Actually, I think we've covered all in terms of this, but can I just actually use the opportunity to say thank you to New South Wales? We're currently dealing with Japanese encephalitis virus, and the response of New South Wales DPI, the Chief Veterinary Officer, Sarah Britton, and her team has been phenomenal. And I think you guys should all be very proud of the team you have, because this is a zoonotic disease that weren't aware of, and their response has been fantastic. So it's just a shout out to your teams and the governments to say, job well done, and the industry is very grateful.
That's great to hear. Thank you for that.
Yes, absolutely. The investment that we spend on the NAMP program, the arbovirus monitoring program, I think has paid us back in spades. I think it gives you a demonstration as to industry's investment in animal welfare outcomes. The Japanese encephalitis is a case study in the nexus between biosecurity and animal welfare. So just be aware it's bigger than just a list of do and don'ts. It's creating a system, if you like, that creates world best outcomes. Do not be embarrassed about what happens in Australia with animal welfare.
Thank you.
It's great.
And I just wanted to make comment back to the animal welfare definition. As you said, there's a lot of different opinions in this space, and I think part of that is we haven't actually defined what we mean when we speak of animal welfare, and it's very difficult to, unless we're going to define that core concept, which is what we're trying to achieve here, it's going to be very difficult to come up with an effective regulatory framework. How can we regulate what we haven't defined we're trying to achieve?
Thank you very much. Thank you all very much for your evidence.
Thank you.
Thank you.
I think there were a couple of matters that were taken on notice, and so the Secretariat will liaise with you about following those up. Thank you.
Chair, what's the timeline on getting responses back?
It is
21.
21 days. Thank you.
Thank you.
Thank you all.
Fine.
Is everyone settled? Okay. Let's get my list. Well, thank you for joining us. We move to Mr. Robert McCauley, who's the Head of Legal for Greyhound Racing New South Wales, Ms. Kirsty Harper, Membership and Advocacy Manager from the New South Wales Greyhound Breeders, Owners and Trainers Association, and also from that organisation, Mr. Stephen Noyce, Membership and Advocacy Manager. I thank all of you very much for joining us today and look forward to your evidence. Can I ask each of you to please state your name, position and take either the oath or affirmation? Thank you. So, yes, starting with Ms. Harper.
Christy Harper, Membership and Advocacy Manager for the New South Wales Greyhound Breeders, Owners and Trainers Association. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr. Noyce.
Hey, good afternoon. Stephen Noyce, General Manager, GBOTA. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. And Mr. McCauley.
Thank you, Madam Chair. My name is Robert Gale McCauley. I'm External Legal Counsel for Greyhound Racing New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth, so help me God.
Thank you so much. I will ask each organisation if it would like to make a brief statement to open, and then we'll move to questions. And I think you've seen how they're being asked in an informal way. And then at the conclusion, just a minute for each of you in case there's something that you feel we needed to have included that we missed. So thank you for that. Maybe Mr. McCauley, can I ask if you have an opening statement?
Sure. Madam Chair, I appear today to represent Greyhound Racing New South Wales, which is the statutory authority that regulates commercial greyhound racing in New South Wales. It does not in and of itself have an integrity role to play, but which is done by Greyhound Welfare and Integrity Commission, but of course inherent in all of our activities are a welfare and integrity focus. Animal welfare is absolutely core of what Greyhound Racing New South Wales core business is, and so there is a constant literally a constant review of ensuring that best practice is always achieved. You folks may very well know that that a very high bar has been set for greyhound welfare in New South Wales with a code of practice which is probably the most significant and highest standard of animal welfare of any description in the world, let alone greyhounds. And to that extent, much of what is proposed in the current bill is either merely duplicative or somewhat below the standards that are already met or exceeded by greyhound racing. There is one particular aspect of the bill that goes way beyond being merely duplicative. Sorry, I should point out when I'm talking about duplicative, I'm talking specifically about bans, for instance, on live baiting and things like that.
Sure.
Transport of animals, all of these things. The current suite of industry codes of practice, the current Greyhound Racing Act and the Greyhound Racing regulations all provide a basis that either meets or exceeds the standards proposed by this bill, with one exception, and that is the proposed complete ban on surgical AI, which is contained within the draft bill. That proposed ban would have a gross negative effect both on the welfare of greyhounds in New South Wales and breeding of dogs more generally in New South Wales. And Greyhound Racing New South Wales is implacably opposed to it because it would in fact reduce the welfare of greyhounds in New South Wales.
Thank you, Mr Macaulay. Ms Harper or Mr Noyce?
Christy lets me open the batting, and then I'm always happy to pass the ball on. It's Christy and my great privilege to represent all of the greyhound breeders, owners and trainers in New South Wales. And we feel very lucky to do that on one hand, but we take that privilege quite seriously. And we always take the opportunity when we get this chance. You know, everyone in this room gives of their time, so it's our responsibility to make sure we provide a professional submission that meets the questions that are asked. We always want to be balanced, and we always want to try and be solution-based. One concern we had with this process, we thought the initial consultation, which we provided some feedback, had nothing to do with artificial insemination, for one, and there are a number of other issues that weren't covered in the consultation. So, as I say, we take our role in consultation seriously and professionally, and I think there was a big gap there, which I think is something we need to consider moving forward. There is a picture in our submission. I guess our brief is cradle to couch. You know, that's our responsibility. There's the joy of the new birth and then the racing and right through to the end. I think simply in that way, Christy and I and our colleagues from Greyhound Racing New South Wales worked hard with the government to create a code of practice that was launched in June 2020, and the then Minister for Better Regulation and Innovation, the Honourable Kevin Anderson MP, who's now the Minister for Racing in the state, said, as a result of the code, New South Wales will now be leading Australia, if not the world, in providing standards for the protection of greyhounds that reflect public expectations. These include the largest requirements for greyhound housing in the nation, in addition to setting out high standards of socialisation, exercise and enrichment, and is also the first code to contain standards that apply to retired greyhounds who remain in the care of industry participants. So we've already set this really high bench, and then there's other people now looking at some duplication. The Treasurer at the time when COVID first hit our state, who's now the Premier, said at the time, we will only survive this pandemic through creating more efficiencies. Now we're talking about us setting the highest standards in Australia and possibly the nation, and now all of a sudden there's this proposed duplication of roles. So, and again, as Rob said, the angst that the breeders and the owners and the trainers felt with the support of Greyhound Racing New South Wales and GWIC, the Minister, the recently appointed EPI Minister, Minister Saunders, agreed to meet us up in Dubbo, so we all went up, and Christy was saying earlier, the participants were all really surprised but really impressed that the three organisations who can have our own little challenges got together, and it was an interesting meeting in that everyone took their guns and their tanks and their armour, and the Minister got up and said welcome and said, I think this meeting will be a little bit different. My plan is we will take the artificial insemination out of the bill. And it's funny, in a room like this, it took everyone about 10 or 15 seconds for it to sink in, and everyone applauded. So from our point of view, certainly we support the Minister's strong stance, and I'm certainly hoping that has been removed from the bill. So then ours is about really the duplication, and certainly my colleague is much better placed than me to talk about that. Thank you for the opportunity, but we really do appreciate it.
Thank you very much. Okay, questions? Yes, Mr Benasiak.
Can I pick up on a couple of those points? Mr Macaulay, I know you mentioned how this ban on the insemination doesn't just necessarily impact greyhounds, but it impacts all breeds of dogs. I think that's important to note, because I think a lot of some of the rhetoric around or concerns around this sudden pulling out of this ban out of the bill has been that it's been to appease the greyhound racing industry. But when we talk about the negative impacts on animal welfare by not allowing this to be an option, given that having a good gene pool of dogs is important. Gene pool for dog breeding is important. Like, we can't have a shallow gene pool.
Yes, thank you, Mr Benasiak. I'm a lawyer. I don't profess to be a veterinary surgeon, but when this bill was presented and we were asked to provide feedback, I did personally take it upon myself and the organisation to go and look at what happens in the industry with artificial insemination. And those wanderings took me to two of the leading providers of artificial insemination for canines in New South Wales. One is the Orana Clinic at Dubbo, which I went and had an inspection of and interviewed all sorts of staff there, and another is a veterinary surgeon who is the leading provider of and indeed a world-leading provider of artificial insemination in canines, and he's based here in New South Wales. And what is clearly apparent is that artificial insemination in both of those practices is done for very good reasons on all breeds of dogs, not just greyhounds. Greyhounds represented a significant part of both of those practices, but I saw when I was there that they're doing all sorts of working dogs, and you would all be aware that all sorts of working animals, whether they're racing animals or stock working animals or stock protecting dogs nowadays, are all extremely valuable. Everyone has got a bit of an education recently with this muster dog program on the ABC, where we all suddenly realise that dogs are worth $10,000, $20,000, $30,000, $35,000, and therefore those dogs are very protected, mollycoddled to breed. And the welfare component of this AI, surgical AI, means that a dog can whelp once and get as many as she might have got naturally with 2 or 3 whelpings, and it is done carefully and regulatory and with genetic precision, so that you can breed away from what might have been weaknesses in certain dogs. Greyhounds, for instance, sometimes have a weak hock, or other breeds have a bad hip, and proper breeding programs can be put in place and followed distinctly to ensure the delivery of better genetics for all dogs. And I do think it's very important that we're not neglecting. Sorry, I might just pick up on something that Mr. Noyce said, which was that the greyhound industry was not consulted about this at all. This particular ban appeared in a second draft of the bill, post-public consultation, and so there's no, until now, and our submissions, there's never really been any public feedback. There was one single industry player in New South Wales who was consulted belatedly about this, and that organisation was the Greyhound Welfare and Integrity Commission, and you have received their submission, which speaks for itself. But it's very important, Mr. Banasiak, in relation to both greyhounds and all other breeds.
In terms of the duplication, which you've sort of both picked up on, would it be an easy fix in just saying, for the benefit of any matters relating to greyhounds, please refer to the
Code of practice.
Code of practice, or the GWIT, the legislation around GWIT, so that you aren't essentially having that duplication and that potentially confusion as to which legislation am I looking at now.
I think that is a very valid point. Greyhound, what we call participants in New South Wales, they might be breeders, owners, trainers, handlers, houses. Greyhound participants are subject to a very significant slew of rules and regulations, various codes of practices, the rules of racing, the Act and the Bill, as well as all of the current animal welfare legislation and regulation in New South Wales, POCTA, etc. And to add another level of statutory complication to that, another whole slew of rules for people to know, and another whole slew of people who can come, I don't say this disrespectfully, breaking down their door, coming without a warrant at any time of the day or night, is not only duplicative but is onerous for the good citizens of New South Wales who are in the dog industry, or specifically the greyhound industry. This bill starts out with a number of proposed regulations about such things as feeding, watering, housing. All of those things are exceeded by the Greyhound Code of Practice, and in our respectful submission ought not be. The greyhound participants, and frankly dog owners in general, should not be subjected to duplication of rules, particularly, I might say, when the rules that are proposed by this bill are in fact of a lower standard than those already on foot.
Sorry, can I just clarify, Mr. Macaulay? Did you say that we had understood it was one form of AI that was being banned? You seem to be intimating all of it.
No, sorry, surgical AI is specifically what is proposed to be banned.
The committee is just trying to understand the fact that there appear to be more humane methods available, and I suppose that is going to be really the particular issue that we're interested in understanding.
Yes. I might say the other main method is Transvaginal AI, and we are not aware, Greyhound Racing New South Wales is not aware that there is any scientific or veterinary literature which supports the late inclusion of a ban on surgical AI in dogs that was included in this bill. We have specifically asked for it, and none has been provided.
I understand. So just in terms of the procedure itself, how much of artificial insemination would be done by that method?
Yes, so by the latter method, the proposed ban method, the surgical AI method, about 80% of greyhound breeding in New South Wales is done by surgical AI. And I might indicate, Madam Chair, that it's done there is only about a dozen clinics in New South Wales that do it. It is a very expensive process to set up a specialist surgery for surgical AI in canines. The two that I am familiar with are really world-leading practices, and they are as good as any modern hospital ER room I've ever walked into. When we talk about surgical AI, we're talking in fact an incision in the skin that is about 10 millimetres long, I understand never longer than 12 millimetres long, undertaken under general anaesthetic, so there is no pain felt by the dog. I have been and witnessed it myself. There could be no genuine argument from what I have observed that the dog is under any pain or duress or exhibits any problem whatsoever. It is then closed with one or two. The procedure takes about 7 minutes. It is then closed with one or two stitches. But what it saves, what it gives, firstly, is what Mr. Banasiak has referred to about the improvements to the gene pool and very specific breeding for traits. But what it also supplies or saves in Australia is massive savings in transport of dogs around the place for breeding purposes. We have the tyranny of distance in this country, that we're not only big internally, but we're a very long way from other sources of genetic material. And so what surgical AI uses is frozen semen, and it is frozen in batch straws that contain about 100 million motile semen, and it means that you can have a dog sitting in Perth or indeed in Dublin, and without transporting the dog and without subjecting it to quarantine or anything else, we can utilise the best available semen anywhere in the world to breed a better dog. And that must, on any reasonable assessment, give a better welfare outcome when you're not carting either dogs or bitches all over the countryside to breed.
Sure, and please be assured, I don't think anyone's considering banning AI.
Thank you.
Anyway, sorry.
Yeah, thank you. I've got some follow-up questions in regards to the concerns around duplication of the legislation. I guess I've got two sort of questions. I guess one is if it is simply duplication that meets or is less than, what is the angst about that duplication in and of itself? But second of all, when I'm looking at some of the concerns that have come through in the submissions, for example, live baiting, and removing that from POCTA, in the actual Greyhound Racing Act, it actually refers back to POCTA in regards to punishment for live baiting. So if it wasn't in the new version of POCTA, then that would be removed. And the only other part of the Act is that you'd get your registration cancelled. And the same with the rules. And so the rules under the Greyhound Racing rules, again, it would lead to a disqualification. And then again, it refers the Act again, which if it was removed from that. So that would actually significantly reduce the outcomes of somebody that was found to be live baiting on their property to just disqualification and having their registration cancelled. Are these the sorts of things that you're calling for, to have them actually removed from the Animal Welfare Act?
No, Ms Hurst, we're not calling for them to have them removed. The industry is perfectly not only content, but it is the one that is regulating itself as far as the ban on live baiting. There is zero tolerance anywhere in the industry for that sort of behaviour, and so there is no call for a lessening of restrictions.
You support it remaining in the new legislation as a criminal offence?
Yes, we would, or what we'd, I might say that more accurately, is that we wouldn't oppose it being there because it has a role, a clear role to play. I might say while we're talking about that it is the industry before GWIC became active that prosecuted and drummed out of the industry what you might call the rump of old-fashioned bad players that weren't acceptable then, and they are absolutely not acceptable now. And so whilst it remains something that obviously ought to be banned, there is very little work for it to play, the ban, because we don't see it as an offence that is occurring. I want to be very careful. I'm not advocating here for a removal of a ban on live baiting. I'm suggesting to you that it is a very old-fashioned practice of the past that has been entirely stomped on by the industry, by every player in the industry, by Jabota, by GWIC, by GRNSW, and every responsible industry participant in New South Wales. There is nobody in the industry who would accept such behaviour nowadays, and therefore it has a strong role to play. Let me just turn quickly to your duplication question. The duplication becomes problematic only because it is, when it is duplicative either only to an equal standard or below, it nonetheless empowers a whole different group of people to come along and police something that is already very highly policed. Participants in New South Wales are used to now, a few years in, dealing with GWIC and GWIC inspections of their kennels and their premises, for instance, under this. And why I say it's duplicative but not exceeding the current arrangements is, for instance, for inspections, a GWIC inspector can come along to someone's residence and enter their residence without warrant. Under this bill, there is no such proposal. They would have to have extraordinary or exceptional circumstances to enter a premise. The GWIC inspectors are already authorised to come and inspect all of the things that are within the code of conduct, and they include things that this bill starts out with. So they are things like water, feeding, accommodation and transport of dogs in particular, and all of the things that are in here are less than the standard that is already adopted, but I might say adopted voluntarily by the industry and now encapsulated in the rules.
But we have identified, obviously, one thing, which is live baiting, which doesn't sort of exist strongly in the other acts. So, I mean, I suppose if we were going to leave one aspect of like such as live baiting in the Animal Welfare Act, it's almost like then there's that crossover remains anyway. And obviously we can't remove it because it's so much weaker in the other acts and doesn't sort of have any kind of criminal responsibility to it. So
I don't have Rob's experience legally, but no one on this side of the table or anyone in our industry supports live baiting.
I'm not suggesting that you support it. I'm just saying that it's
So
currently there's only really one act, which is the Proctor Act, which has really strong legislation around live baiting.
Yeah.
And so I'm saying, you know, if we removed it all from that act, then we've got potentially, you might have one bad apple that does do it.
Yeah.
And then that person, then all they would be facing would having registration cancelled or disqualified.
In our submission, we talk about concern about vagueness and wording. I guess what I was getting to, if everyone in this room doesn't accept in any way, shape or form live baiting, then this consultation process may then deliver the outcome that we're all looking for with just a bit more work on wording and interpretation.
And I guess, sorry, I'm just going to jump in a little bit. I guess it's the same as, you know, when we're talking, and you've gone to great lengths to say that there's no live baiting in the industry or that you're aware of, et cetera, et cetera. You know, nobody here accepts murder, but we still have that in the criminal code. It's very important that if that was to occur, that you do have the powers to deal with it appropriately. So when then it comes down to what you're asking for in your submissions, is it about the duplication or is it really about the exact wording of the provisions that's causing you an issue? And if so, how would you prefer the provisions to be drafted?
Christy might have a go at that one.
I think there are a number of, double regulation across the two acts, but I think the main thing with regard to live baiting is that is very greyhound specific. And this is an animal welfare bill, it's not a greyhound racing bill. And so we would like to see the live baiting clause written so that it applies to all canines. Any canine could be live baiting. And I think that's very relevant, but the wording, I believe, in this is specifically, it is greyhounds. So I'd like to see that, and then I also would like to just tidy up the words so that they're not as vague and as broad as what they are, which I've outlined quite detailed in my submission.
Thank you.
Can I just want to, Mr. McCall, I just want to unpack, I want to go back to this 80% around surgical artificial insemination. What is the 80%? Is that of all inseminations, or is artificial inseminations, or is that of all inseminations?
No, of artificial insemination in New South Wales, about 80% of
So
it.
the other 20%, how are they conducted?
Either a natural joining of dogs or by transcervical flooding.
So the transcervical insemination process, do you have a percentage on how many bitches are inseminated using that method?
I don't have those numbers, no, Mr. Phipps.
And so, as I understand it, some countries have banned surgical artificial insemination of dogs, and they're using transcervical. Why is the preference in the greyhound industry for surgical as opposed to transcervical?
It's because it's much more efficient. It's got a safer outcome for the dog, and there is a higher rate of live-born healthy puppies. So the whelping is better. In greyhounds, all greyhound bitches in New South Wales are restricted to 5 whelpings during their lifetime, and no greyhound over 10 years old is allowed is licensed to be whelped at all. And so greyhound breeding in New South Wales is already very strictly controlled by GWIC. If you want to breed your dog, you have to get a permit to do so from GWIC. and so it comes with those restrictions, and people are paying a very substantial amount of money both for the female being bred and for either a straw or a natural insemination. And so a straw of semen nowadays is worth a very substantial amount of money, tens of thousands of dollars for very good dogs. And all dog breeders, greyhound owners or other dog breeders, are interested in ensuring that that live puppies, live healthy puppies, are whelped in the most efficient and welfare-centric way possible from that investment. Surgical AI has an ability to put more healthy puppies on the ground with a better welfare process for the dog through that. It's a more efficient process. It gives about double the effectiveness of Transvaginal AI.
Okay, thank you. And in just a very broad sense, can I just ask, so moving this taken away just from greyhounds, this reform process has come about in an attempt by government to, I guess, modernise or contemporise the animal welfare legislative arrangements in New South Wales. In a broad sense, do you support that process, or do you think the previous legislation that we had in place, POCTA and etc., was okay?
Mr. Veitch, I'm here with a hat on for Greyhound Racing New South Wales, and I don't care to comment more broadly than the greyhound industry.
Okay.
I would echo those comments.
Okay, Anna.
And if I can also just add to what you just asked Mr. Macaulay about, we were all very privileged to hear from Dr. John Newell out in Dubbo when the Minister was present. And he gave a fantastic presentation to all of the participants and ourselves there on the differences between surgical artificial insemination and TCI. I would, if you haven't already heard from Dr. John and had him in, then I would certainly recommend that you do, because it will kind of blow your mind what he has to say on it. But I believe that probably this goes to the point on things just being put into the draft without any sort of scientific evidence based around it. If we had have looked at the science of it, we wouldn't be having this conversation right now.
Thank you.
Does that mean then you have the science to back up what you were saying before about it being more effective, less harmful? Would we be able to get that tabled?
I strongly believe that Dr. John Newell would be the person that you need to speak to.
Mr. Barrett, I can arrange to supply
Just
that
table
information.
a document with that evidence on it. Yeah.
That's right. This, what Ms. Barrett is referring to, the fellow, is Dr. John Newell, and he really is regarded. He's right here, based in New South Wales, and he is regarded as the world's leading expert on artificial AI, in surgical AI in canines, and he's extraordinarily proficient and well written about this, and I'm happy to supply his information.
Thank you. That would be much easier if you wouldn't mind. It'll be easier for you to arrange that than for us.
Can I just ask as well, and I'm not sure if you're aware of this, but was it Dr. Newell?
Mm-hmm.
Do you know if he's heavily involved in any kind of financial sections of this specific procedure, like importing parts or involved in the surgery or anything?
I don't profess to speak to him, but he's a veterinary surgeon.
We can ask some more questions after he's had an opportunity. Thank you. Have you finished your question, Mr. Barrett?
Yeah, I think.
Okay.
I'd fill some time if there was time available.
You're learning quick.
We can talk about the footy.
Talking thing.
He's learning very quick, isn't he?
We've got a couple of minutes, haven't we?
Doesn't get to do it in estimates.
I guess there's been some pretty big, we've come a long way with greyhound racing in the last however many years. What are you most proud of as far as how far we've come since 2016?
For me, it's certainly our code of practice. The New South Wales GBOTA was heavily involved in consulting on the development of the code of practice, and I'm very, very proud of that document and the very high standards that it sets for our industry.
Could I throw two bob into that? A good question, Mr. Barrett. it has to be the massive welfare improvements and the modernisation of greyhound racing. There are huge welfare improvements in the whole life cycle and life tracking of greyhounds in New South Wales. There has been a 50% reduction in injury rates in racing, and there has been a massive increase in rehoming of greyhounds, and so thus the matriculation, if you like, from a racing greyhound into a pet for life, and that is a major focus of Greyhound Racing New South Wales, and all of those programs have been hugely successful.
And that's come about essentially through self-regulation on the codes and standards.
100%.
Many thanks. Can I just ask each of you, is there anything that you'd like to add by way of conclusion?
Just thank you for the opportunity.
Thank you very much. That's terrific.
Thank you.
Okay, thank you all for your evidence today and for answering our questions.
If there is anything else you need, please reach out.
Thank you. The
More than happy.
Secretariat will follow those up and be asking, if possible, for replies within 21.
My colleague.
And I sent to the clerk the Dr. Newell information. Is that right?
That would be fabulous. We'd greatly appreciate that. Thank you very much. So the
Everyone, thank you.
hearing's now adjourned until 2:45. Oh,
Three.
I'm sorry.
You've got 30 seconds.
I'm reading the 3 o'clock. Yes.
Go.
Ms. Young is an executive member of the German Shepherd Dog League of New South Wales, and Miss Michelle Grayson, a treasurer of the Cat Fanciers Association Incorporated, and you've both made submissions, which we appreciate.
Thank you.
So I would like to welcome you to the committee and ask you to please state your name and position and take the oath of affirmation.
Okay, so my name is Yvonne Yund. I am currently a serving member of the German Shepherd Dog Council of Australia, but am representing the German Shepherd Dog League, which is the state body in this instance. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Ms. Grayson?
Hi, my name is Michelle Grayson. I am the current treasurer of New South Wales Cat Fanciers Association. I'm here representing the association today. I've been on management committee with that association for almost 4 years, and I'll just read the affirmation. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do you have opening statements you wish to make?
Surely.
Thank you, Ms. Young.
Honourable Chairman and members of the Committee of Inquiry, our members support the welfare of all animals and do not believe that the motivation of production for profit should ever override a commitment to ensure that every animal enjoys the best possible life it can have. We acknowledge that our fraternity is not perfect, but within the hobbyist sector, we have in place standards and regulations that advance the cause of animals, identify and hold to account those who do not meet those standards, and membership is voluntary. We had eagerly anticipated this legislation, hoping that it would provide clarity, transparency and equitable inclusion for all stakeholders and interested parties, offering a framework within which the goal of animal well-being could be achieved through collaboration. The German Shepherd Dog League Inc. has submitted a document that outlines only some of its concerns in regard to the draft Animal Welfare Bill, and in summary, we reject the one-size-fits-all approach, the combining of livestock with companion animals, the combining of regulated hobbyists with those who participate in market-driven production, argue that far from clarity, the definitions and expressions adopted in this bill lend themselves to subjective and biased interpretation, challenge the lack of draft regulations, knowing that when this bill is enacted, regulations will be developed by the responsible department without any requirement for them to be returned to this House for approval. Object in the strongest possible terms to Section 7 in its entirety as a violation of citizen rights and expectations in matters of natural justice. Question the lack of provision for appeals and the lack of an ombudsman to mediate in cases of complaint. Oppose the disposal provisions in this bill. Fear that because of our transparency, we will become the low-hanging fruit in terms of any agency tasked with compliance, and that the true offenders will continue to offend. And protest the lack of inclusion of stakeholders that have a demonstrable track record of self-regulation, continuous improvement, and voluntary support of best practice. We ask that you recognise our achievements over many decades and the fact that we are already regulating the activities of our members. We seek the creation of a further class of stakeholder, the hobbyist, and that the demands of this bill are moderated for that classification. We have experience, systems and knowledge to offer in support of the goals of this bill, and we thank you for the opportunity to be present here today to respond to questions you may have.
Thank you very much. Ms Grayson. Ms Grayson, would you like to make an opening statement?
Sure, I would, thank you. New South Wales CFA thanks the committee for the opportunity to attend today and provide information regarding the draft animal welfare policy. We understand and appreciate the challenges involved with combining three pieces of legislation and providing the right levels of powers to enable animal welfare issues and cruelty to be appropriately addressed. New South Wales CFA members are held accountable by our Code of Ethics to all required legislation. In reviewing the draft policy, our specific feedback is set out in our submission. Our recommendations are summarised, and these are that there needs to be further clarity around the increased powers provided to charitable organisations and authorised officers, as well as the accountability for their actions. That an independent body must be established to deal with complaints made against charitable organisations and authorised officers. That people who are charged under legislation must be afforded due process and have access to all relevant information to be able to defend themselves. The draft regulation standards and guidelines must be made available to review in conjunction with the policy to understand all of the intricacies and how this is going to impact breeders and companion animal owners. A specific clarity on whether the breeding of companion animals will be impacted by the inclusion of other licensed animal activities if a breeder licensing scheme is going to be introduced. Clear definitions of commercial in the context of powers of entry, as many breeders of companion animals use their residential homes to conduct activities associated with breeding. We also believe that there needs to be a documented procedure on how charitable organisations and authorised officers are appointed, and that the approval must be via a committee or a parliamentary process and should include some form of stakeholder or public consultation to ensure transparency. We also oppose the use of psychological suffering being used in the definition of harm, as it's very difficult to identify and it's very much based on personal interpretation. Thank you.
Thank you very much. Mr Veitch will ask the first question.
Thank you. My question's to Ms Grayson. Your submission, you talk about section 42(1)(b), the requirements to be licensed, but specifically you say there should be specific clarification of whether dog, cat and agricultural exhibitions or shows fall under the banner of being a licensed activity with clear guidance on the proper intent interpretation. And you go on to say that they should not be included in activities listed in the bill or regulations. Is this because the bill's silent on those particular activities that you raise this concern?
It's more in relation to the inclusion of the Exhibited Animals Act, and there are certain wordings and clauses in that act that relate to definitions of what an exhibited animal is, such as aquarium zoos, petting zoos, those sorts of things. So that's really where our concern comes from, in that, dog, cat and agricultural shows, if they are classed as exhibited animals in the context of the bill, then that could have a major impact on those particular events that those parts of companion animals deal with.
Okay, you're seeking a very specific exclusion then for cat, dog and agricultural shows.
So, well, Potentially. There is a clause. There is a clause in there already that excludes companion animals. So we would just like to seek clarity in relation to whether or not exhibited dogs and cats in agricultural shows would fall under the exhibited animals definition.
Okay, thank you. And your submission also, on another matter, your submission also talks about the prohibited procedures, which is section 22(1)(e). We've had a fair bit of conversation here today around artificial insemination and specifically surgical artificial insemination as opposed to transcervical insemination.
Yes.
First of all, to the Cat Society or the Cat Fanciers Association, does this actually impact upon cat breeders as well? Do you use surgical artificial insemination?
It's not widely used, but it is available if a breeder so chooses.
Okay.
But it's not common practice.
And Ms. Grayson, clearly the German Shepherds would have a view of that.
Yes, we do. We use it widely. One of the things that has held us in very good stead over generations is the capacity to access gene pools that will improve on hereditary disease issues, such as hip dysplasia, elbow dysplasia, those sorts of issues. We regularly, and I'm currently holding personally, 4 breedings from overseas animals that I believe will actually improve my blood stock and will improve the health outcomes for animals. I might just add that over the last 50 years, which is when we've been trying to improve hip and elbow, hip outcomes, we've managed to decrease our score from around 30 to down to 7. So that's an intergenerational and incremental improvement that is largely achieved through the bloodlines that we introduce. To get access to those bloodlines with the decreasing ownership, we do use artificial insemination. And in terms of bringing in international blood stock, we have to use frozen semen, which is best inseminated through the surgical AI. So we strongly support the inclusion of artificial insemination by surgical insemination as an allowable practice. It has been responsible for a lot of our improvements.
On this one.
Just on that point then. So could you just elaborate on that point you made about the that artificial insemination is best done surgically rather than transvically? What do you mean when you say best done by?
Okay, so personally, I'll speak personally because that's the knowledge I have. I use surgical insemination because transcervical insemination is quite daunting for the female involved. She is usually placed in a very vulnerable position with a surgical instrument inserted into the vagina in order to introduce the semen into the uterus. When you use a surgical procedure, the animal is anaesthetised for a very short period of time. A small incision is made into the area of the umbilical cord, and the semen is introduced directly into the uterus. The animal wakes up, I guess, somewhat confused, but obviously in a lot better state than being traumatised by...
Do they ever anaesthetise a dog that's having a transcervical insemination?
Look, to the best of my knowledge, if they feel that the animal is becoming stressed, they may introduce, and it's a question really for the vet involved, they may think that it is better to sedate her slightly, but she will be conscious throughout.
Yeah, but being sedated wouldn't interfere with the effectiveness of the procedure.
No, it doesn't.
Can I just ask a follow-up just quickly? Sorry, I know you've
Yeah,
got
if
some
you
other
stay on this one, if that's what it's.
Yeah. I was just, I was wondering why, obviously we heard evidence earlier today that this is actually, that the surgical AI is actually banned in many places overseas.
Correct.
Does that sort of concern you going forward, or that it has been banned and the reasons why that has been banned?
Okay, well, I would suggest that having carried out the procedure a number of times on my females, I would argue that it's a preferable situation to Transvaginal. I would argue that the European experience is a great deal different than ours. So for a European owner to get access to a viable stud dog or a process is much easier than it is in Australia. So if you wish to improve your bloodlines and ensure against heritable disease and do the best you can, then obviously you want to get access to the best bloodlines. It costs you a fortune. What happens in Europe is sometimes, in my view, quite extreme and quite unrealistic and probably not the best outcome for the animal.
Mr. Barrett.
Question for either or both of the witnesses. Sorry, both of you pointed to the increased powers of authorised officers. In fact, Ms Young, I think you suggested you objected to the entirety of Division 7.
Yes.
Can someone point to me what the increased powers are rather than just clarification of existing powers?
They aren't clarification. Currently, if an RSPCA or Animal Welfare League officer wants to enter your home, they have to have a warrant or a police officer.
To your home or your property?
No, to your home. Under this proposed legislation, it is our understanding that without warrant, they can arrive at your front door and demand access to your entire property, entire home, which is why we have very grave concerns. We have very grave concerns. If, for argument's sake, I were a murderer, a warrant to come onto my property would have to be obtained, whereby the inspectorate would have to, or the police officer would have to go to a magistrate, prove why they need that warrant, and assure the magistrate that at the end of it, they would have an arrest. That puts, if our interpretation, and I believe it's widely held that that's the interpretation, if it's correct, we're being accorded less rights than a criminal.
Yeah, I don't disagree. I'm just trying to see in the Act where that is. I'm not saying it's not in there. I'm just saying I can't point to it.
So that would be why we are objecting very, very strongly. It's against natural justice. It doesn't provide for anybody to have, prior warning that somebody is coming into the home. Many of our members and many of the cat people are in advancing years. And quite frankly, somebody turns up at your door and says, I want in and I've got the right. They're going to be totally intimidated. They don't have the right to have somebody there with them. It's draconian.
Yeah. Can I just follow up, Ms Grayson, just following on from this line of questioning. Your submission talks about the fact that it says this section does not provide any details as to what activities are prescribed or not, as the draft regulations are not available. Would it make it easier for people if we had draft regulations to consider at the same time as the draft legislation? I'll start with Ms Grayson and then Ms Ewan.
Yes, it would. It would make it very much clearer for people to be able to look at the regulations and the terms and the definitions, to be able to assess how that might impact them or their organisation.
Okay.
And we believe that that it must be provided.
Sure.
Okay, so from our perspective, the fact that there is no regulation provided with this document is very problematic, highly problematic, because whilst the bill has to come before this House, the regulations do not. The regulations are developed by the responsible department and are subject to departmental interpretation of the definitions, of the terms, of the scope. They don't have to come back to this House for approval. So we find that totally objectionable, because when you have a bill that is worded the way this one is, unreasonable, the term unreasonable, the term unnecessary, what does that mean? In reality, what does that mean? And then I have to read it in the context also of the companion animal bill. I mean, it's a minefield, an absolute minefield. And we're very, very concerned that if I could just digress a little bit, if you look at the inspectorate for the welfare organisations, the average tenure currently is a 3-year term. So my understanding is that the way those people are recruited into the sector is that retired police officers are preferred because they know the law. They come in, they are shadowed with a more experienced officer for a period of time, and they then do internal training. But nowhere is it stipulated that they have to have qualifications in animal welfare. So it's then open to personal interpretation as to what is and is not a welfare issue. Given the wording of the bill, without the regulations present, we can't know what those officers are going to say. So if I were to say to you, a Saluki, that's a breed that is a greyhound type of breed. It's been bred in the Gulf areas for generations as an aid to hunting. The dog, when you look at it, should have very thin cover on the rib cage. They're a running dog. Now, without training in animal welfare, that officer might walk in and say, that dog's underfed, when in fact that dog is at optimal condition. In my breed, it's the same thing. You tend to keep the animal leaner rather than fatter because of hips and elbows and those sorts of stresses. Without the adequate training and the adequate knowledge and the experience, what assurances do we have that subjective things are going to happen, that the regulations are actually going to match the intent and spirit of the bill? There's none. So we would argue that without the regulations, this particular piece of legislation is a minefield and very, very threatening.
Is it a minefield and threatening because of the unknowns?
Yes. Okay. And some of the provisions in the bill so far, but yes, the unknowns and the interpretations, the subjective interpretations concern us.
Okay.
I've just got a question, if I can jump in now, for Ms. Grayson. You said in your submission that there should be an independent body who does not report to the Minister to oversee the Act and the enforcement agencies. I'm wondering how you see this working and what role it would play.
And who does it report to?
So we would see it such as an ombudsman type role, where they're an independent body, they're an independent party that a person can make a complaint to in relation to a charge or conduct of a charitable organisation or an authorised officer. It's a bit like you're making a complaint to the RSPCA or AWL about them. What certainty does the person making the complaint have that it's going to be independently assessed and reviewed? So we would see it that it would be an independent body or an independent party, as I say, such as an ombudsman or a commission of some description, that is not reportable to a particular minister. It's totally independent, to give certainty or to give that separation between the complainant and the people that they're complaining about.
Thank you. I'd also like to ask you about your code of ethics, which states that your members must ensure that cats with a known history of physical or genetic defects that might affect the cat's quality of life should not be used for breeding. I just wanted to get your thoughts around that and whether that rule should actually apply outside of your organisation as well.
So we believe that it relates to any breeder that's breeding of any animal. If there's a disease or if there's something in that particular male or female that causes heritable diseases or causes issues, then there needs to be serious consideration as to whether that animal is still suitable to be bred with and to continue that line. Not just cats, dogs, horses, rabbits, doesn't matter to us. It doesn't matter what type of animal it is.
Okay, so you want to make sure that, obviously if somebody is going to be intentionally breeding, that they're not intentionally breeding where there's going to be harm caused to the animals that are born.
That's correct. Because it's about the welfare of the animal. If you're breeding an animal and you are breeding with something that you know has a defect, then you are setting that animal and its offspring up for failure down the line and in the future.
Yeah, absolutely. Thank you.
Sorry.
Oh,
Chair.
apologies. Yes.
No, you're right. Can I just turn to Ms. Grayson? Can I just turn to your submission where you talked about the membership of the Animal Welfare Advisory Committee? And I may ask you, Ms. Yung, in terms of your opinion on this as well. What's your understanding at the moment in terms of its makeup and whether it does, its current makeup, does it have a balanced approach in your opinion?
We don't believe that it does. We don't know that much about it, to be fair. We don't know what the criteria is for someone to be part of that committee. We don't know which stakeholders are involved or why they're particularly involved. We just think that there needs to be a bit more clarity around how those sorts of committees are established and made up, who's involved in it.
Ms. Yung, do you have anything to add?
We have concerns, serious concerns about the membership, because it is our belief that a number of the organisations that are currently there have boards that are not open to public membership. They're appointed boards. They are made up largely of former senior departmental people. So we don't feel that there is balance in the organisations themselves, that there is a bias, that there is an agenda that's not necessarily open to be contested. We are concerned about the amount of uncontested funding some of those organisations have. And we are also highly concerned that it is not open to regular public comment. In this day and age, when we're all getting very used to online meetings, Facebook pages, feedback through social media, we're highly concerned that some of these committees can be hijacked by a single agenda and that it's not open to comment and feedback.
Just looking at the proposed division in terms of the makeup, it does seem quite broad and quite vague, and not really prescriptive about, I guess, picking or targeting specific elements or particular groups or people that may have something to add to the Animal Welfare Advisory Committee. It's quite broad, but doesn't go and say, well, look, we need to have someone from a dog breeding association. We need to have someone from, cat breeding association. It's quite broad. Would you like to see a bit more prescriptive about, we need someone that has expertise in this area, we need someone that has expertise in this area, rather than this just broad, open sort of, we'll take anyone that has apparently relevant skills?
Okay, so what is relevant skills?
Well,
that's the question.
I think you hit the nail on the head there.
Would I presume to tell a farmer about how to keep a sheep? God, no. Should somebody who's never had experience of breeding a dog or caring for a dog, should you tell them how to breed a dog or what to do? I guess it's a question of, this bill is trying to cover all bases, and that's okay, as long as you recognise internally to that bill that livestock, and that's what we're broadly being covered as, livestock is an animal produced generally for consumption and sale. It's a profit crop. A companion animal is bred to stay with its master or its owner for life. So there's a totally different philosophy in that. One is being bred for consumption, one is being bred to, keep it alive as long as you possibly can if you're a decent human being. So I think you need representation from the commercial sector and representation from the hobbyist sector. I believe that we are in a position as one peak organisation, and I'm sure the cat fanciers are the same, we are in a position to support that and help that. And we need to be stakeholders. We need to be recognised. If I can just go a bit further, my organisation had to fight a ban on importation of almost 50 years. We are aware of how unfair legislation can be. To establish our credentials, we had to establish animal welfare as our priority. So for the last 50 years, we've been breeding to eradicate or minimise the impacts of hip dysplasia. In the 1990s, we were the first country in the world to recognise elbow dysplasia and to put in processes where that could be eliminated. So I think we've got a lot to offer. We have a code of ethics, we have a code of conduct, we have a situation where in order to become a registered breeder at Dogs New South Wales, the intending person has to go through training. They have to pass animal husbandry exams. Whereas the guy who's got cattle dogs for sale on the side of the road is not. And, he's just there for production for profit. So our view is that needs to be improved significantly. There needs to be more inclusion. And I think there's a wealth of knowledge out there that can be brought in through electronic and digital means to support a balanced and a very much improved view of how this is run.
If no one else is looking to ask something, I might just go specifically to your breed. Does your lead have anything to do with, I guess, the provision of German Shepherds for, the working role, as in law enforcement, customs, and how do you see that potentially being impacted by some of these proposals?
Okay. Well, I'll firstly come back to a couple of our challenges. The German Shepherd dog is a working dog. He's a working breed. He was originally bred in Germany for sheep work, but not sheep work in the sense of the kelpie in the yards. He was bred to guard the sheep and keep them together. His working traits are very, very strong. So occasionally you will breed a dog that is not suited to be in the hands of the average person. And this is where experience and knowledge comes in, you know. The number of people, I'll again draw on my personal situation. My last litter, I had 99 applications to take a dog. I had a litter of 6. So I had the luxury of being able to choose suitable homes for the personality of the puppies involved. Having said that, occasionally you'll get a dog or a puppy that is just too dominant. Those dogs are very much suited to the working forces. And I know that New South Wales Police actually have a breeding program where they select for a hard-natured dog, the sort of dog that you and I don't want to own. I know that the that the RAAF takes dogs that are so hard the average person couldn't take them on. Now, that's the German Shepherd, and by comparison to Belgian Malinois, we're pussycats. Belgian Malinois are dogs that will not let go. They are, in some instances, I would consider manic. Those dogs are better suited in the hands of experienced people. So what you're suggesting with this bill, to breed for purpose and to breed the right dogs for their needs, they need to have access to bloodlines, to breeding practices to select and breed specifically those type of dogs. Now, I would suggest to you that I breed against that because I don't want Joe Public to have that dog. So I think this will impact them very, very severely, and it will impact their capacity to do the job they're being asked to do. So in terms of the Air Force, those dogs are bred as perimeter dogs. So they are there, the minute anybody comes over the fence, they're a dead man. The dogs that are used in the prisons are as hard as nails, and they have to be, because it's their purpose to protect their handler and to keep order. So this bill has potential to eliminate proven working capacity and access for Australian services to the right sort of dogs and the right sort of animals.
Thank you.
Interesting. Yes.
Thanks. Ms Grayson, your submission talks about the process for approval of charitable organisations, and you make it very clear that your preference is for the charitable organisations to be enshrined within the legislation, not left to regulation. Can you talk through why you have that position?
So our position around that is, we see it very frequently that there are certain parts of society that infiltrate other areas. Sorry, need to gather my thoughts for a minute. So we think it's necessary that charitable organisations need to be approved. There needs to be a process around that, so that we don't end up with certain areas or certain parts of society infiltrating these parts of legislation, such as people who are looking to have a certain agenda or to have a different agenda than just preventing animal cruelty or promoting animal welfare. So that's why we believe that there needs to be a higher oversight as to who is approved, so that there is transparency as to who is being approved to enforce this legislation. Sorry, that probably didn't make much sense.
Okay, but as a part of that process for approval, are you saying there should be legislated requirements before that an organisation is assessed against before they're approved as a charitable organisation? Is that what you're trying to say?
Not necessarily. What we think is that charitable organisations or anyone who is approved to be an enforcer of the legislation needs to have the right intent and needs to have the right focus to be able to enforce legislation without hindrance of other factors that are behind what they're aiming to do.
Oh, sorry, Mr. Barrett.
Ms. Grayson, have you got examples of where that hasn't been happening?
So, look, we've seen in the media and we've seen it in public, in public forums where development applications are sent to different local councils. And I'll use, the breeding facilities as a specific example. There are development applications submitted to councils, and there are parts of society that will fire up, for want of a better word, people to submit objections. Councils then feel or are then influenced by the volume of objections that come in, and many of those objections come in from people who don't live in that local council area. So that's probably the clearest example I can probably give at this particular moment.
Thank you.
Thank you. If I could just ask one follow-up question in relation to our artificial insemination discussion, Ms. Yoon. If it's possible to anaesthetise a dog that's undergoing the transvaginal insemination, as opposed to, if it's possible to do that, then why don't breeders do that instead of the surgical?
Mainly because of the veterinary profession. They won't totally anaesthetise an animal unless when they're doing a TCI.
Mm-hmm.
I have to admit that I've had one very poor experience of a TCI, and it led to a uterine infection called almost a pyometra.
Mm-hmm.
Which could have been fatal to my animal.
Yep.
So one of the benefits, from my perspective, of a surgical AI is that it's carried out in a sterile environment.
Mm-hmm.
I know that the instruments and everything that's being used is sterile.
Mm-hmm.
Whereas in a TCI situation, you don't have that assurance. I always remain in the surgery whilst my animal is being treated or inseminated. And most vets don't allow you to do that with a TCI.
So it's not necessarily about the procedure itself, it's about the practice goes around it by convention, by the sounds of it then. So vets don't do this, they don't make it completely sterile, they don't tend to put them under, they don't do those things, which they do with the surgical one.
Yes.
And so then that's where perhaps the issues are arising.
Also the fact that, do you know very much about the cycle of Okay, so unlike the human being, the female dog actually produces in the cycle all of the ova, so that it's a new production line, if you like, whereas humans are born with the eggs on board and they just release on a cycle. The problem is that TCI, in some instances and with some animals, can lead to severe stress. That can impact the viability of the mating. you may end up with a low, which she may miss altogether. With a surgical AI, you have far better control over her stress levels, over any issues of sterile environment, over issues of actually getting the semen where it needs to go. It can be very, very closely located into the uterus and near to where the ova are floating about.
Okay. Thank you. I think we've got some vets coming at some point and we can also ask, so
Sure.
that's really useful. Thank you.
Can I say there's only 1 moment left, so I might ask both of our witnesses if there was anything that you felt that we'd missed or wish to say to the committee before we conclude. So can I ask you first, Ms. Young?
So I'm the talker. Look, I choose to belong to an organisation that regulates what I do. I am assured with that regulation that it applies to every member involved. I'm also belonging to an organisation that doesn't just do the breeding of dogs. We do dog showing, we do trialling, we do earth dog, we do all sorts of things, all of which are valuable activities for dogs. We're not perfect. But the problem with today's society is that it's come to a point where it's, oh, cheap is good, where I can go out tomorrow and buy a caboodle or a broodle or something else, where there's been no concern, no hereditary information available. That dog, that female, put them together, we'll get a trendy little dog that will sell off for 5,000, 10,000, whatever. For me, that is abhorrent because it's instant gratification for the latest fashion that is around for what I should have in my handbag. The problem with that is that there is a philosophy in the community that it is disposable. It's no longer fashionable, so I'll get rid of that one and get the newest trend. And I think if you were to look at the Gumtree ads last weekend for the Sydney Basin, there were 1,225 advertisements for dogs and cats. I would hazard a guess and say 95% of those were not members of our organisation. So if you want to go to the source of the problem, you look at the production. And the production needs to be twofold. One, you make it illegal for anybody not a member of a recognised organisation to breed or produce companion animals. You make it that they have to belong to an organisation that has a good code of ethics, a strong regulatory system, and one that keeps records and is transparent, which is why I'm arguing you need to include us as stakeholders. I'm also suggesting that the other option you have is that before someone in this state can buy a companion animal, they have to do some training. It could be delivered online through the department. It could be digital. They have to do some training. They have to understand what their responsibilities are from the outset. Once they've completed that satisfactorily, they get a licence so that when they come to me as a breeder, I have some assurance that they, one, are who they say they are, and two, have some skill and some knowledge of the obligation they're undertaking. Thank you.
Thank you very much. Much appreciated. Ms. Grayson, do you have final remarks?
So my final remarks would simply just be that New South Wales CFA don't support animal cruelty in any way, shape or form. Many of the general public don't support animal cruelty or poor welfare outcomes in any way, shape or form. A large proportion of, our animal-loving members in our communities are not necessarily aware of their rights as to what they do when someone knocks on their door and says, I need to come in and I want to inspect your house, I want to inspect your property, I want to inspect what you're doing. So I think it's very difficult, and I appreciate, and New South Wales CFA appreciates the challenges and the difficulties in having legislation that allows the prosecution and investigation to weed out the people who are doing the wrong thing, whether they're breeders or pet owners or whoever they are. We acknowledge that it's challenging. We acknowledge that it's difficult. We have worked for many, many years on many different inquiries, select committees, with the Responsible Pet Forum, with DPI, all sorts of different inquiries. We've provided submissions, and I think it's time that we need to start putting some things in place, the right things in place, to be able to move forward and to stop going round in circles with legislation and with changes and with recommendations from all these different committees and all these different inquiries, so that everyone can move forward and be able to own their dog, own their cat, do whatever it is that they choose to do. So I guess that sort of sums me up, really.
Thank you very much. Look, can I thank both of you for your evidence today? It's very much appreciated. I think there may be some issues that were taken on notice, and if so, the Secretariat will be in touch with you just to discuss that follow-up. So thank you very much.
Thank you.
Thank you.
And those were our last witnesses for today, so I will close the hearing.
Do we have a deliberative?
Short deliberative?
Yeah, sure.
Just have a short deliberative. Papers.